correctly on the indictment.
For those of you on Zoom, it took me a minute. I normally take you first. We had to update the software, so I'm going to do a couple things in the courtroom, then I'll be right at you. All right, cause number CR 21-0813-173, the state of Texas versus Esteban Rivera. Set for arraignment, Mr. Green.
Judge, Mr. Guevara's name is spelled correctly on the indictment. Understands what he's been accused of, would waive the reading of the indictment, enter a plea of not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive two new dates there in writing. That's December 8th at 9 a.m. for discovery status, and then again on January 12th of 22 for pretrial. So if you get out of jail between now and then, I need to see you back on those dates.
Judge, I'll ask that you sign a protective order for CPS records.
Okay, any objection?
Ricky Frosch, Judge.
Ricky Frosch. This is cause number CR 21-0867-173, the state of Texas versus Ricky Frosch, set for arraignment. Mr. Green.
Judge, Mr. Frosch's name is spelled correctly on the indictment, understands what he's been accused of, would waive the reading of the indictment and enter a plea of not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive two new court dates in writing. That's December the 8th at 9 a.m. for discovery status, and then again on January 12th of 22 at 9 a.m. for pretrial. So if you get out of jail between now and then, I need to see you back here on December 8th. Sir, thank you. You can have a seat as soon as you receive that.
And the last one is Destiny Trussell.
Destiny Trussell. Destiny Trussell. Is there a Destiny Trussell in the courtroom? I see no one. I hear no answer. There's not a Destiny Trussell appearing via Zoom. Mr. Schmidt, can you hear me? Thank you. Just want to make sure y'all can hear me. All right, time is now 9:18. The docket was set for 9 a.m. There is not a Destiny Trussell in the courtroom. Her name was called 3 times in the lobby, no answer. The court will entertain a motion. Granted, capious of issue, she'll be held with no bond. And again, I'm here all day if we find it. Thank you, sir.
That's my business, may be excused.
Yes, sir. All right, I'm going to handle this. Who do we have in Terrell? Kevin? Okay. Mr. Schmidt, we're going to handle Khadidra real quick.
Yes, sir.
Let me get to the right page. All right, Ms. Denson, can you hear me?
Yes, sir.
Okay, and who are you there with, do you know?
Mr.
I'm
I don't know in that world.
I'm Dr. Dunn, Your Honor. Ms. Denson's regular doctor, Dr. Votz, is having some child care issues today. but I did see Ms. Denson. I filled out a physician certificate on her less than 1 month ago, and that should be filed with the court.
Okay, well, I'm going to call this case for a commitment hearing then. This is cause number CR 19-0474-173, the state of Texas versus Khadidra Denson. And is the state ready?
We're ready, Your Honor.
And on behalf of Ms. Denson,
Yes, Your Honor. Ready.
and so what are we doing today?
Judge, since Dr. Votz is unavailable, I'm going to offer his physician's certificate as Exhibit 1, and then I'm going to elicit some testimony from Dr. Dunn.
Okay, any objection, Mr. Schmidt?
No objection, Judge.
Admitted. And let's see, Dr. Dunn, if I can get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, you can lower your hand. Danny, if you'll move this way just a little bit.
Sure.
There you go. Now you can see you.
Dr. Dunn, can you hear me?
I can.
Would you state your name for the record, please?
Mitchell Dunn, MD, that's spelled D-U-N-N.
And Dr. Dunn, how are you employed?
I'm the medical director of the forensic program at Terrell State Hospital. Also have a private practice in general and forensic psychiatry in Dallas, Texas.
Okay, so you're a medical doctor, correct?
That's correct.
And Mr. Schmidt, would you stipulate to his training and qualification and experience to be an expert?
I will.
Okay. Dr. Dunn, are you familiar with Khadidra Denson?
I am.
Is she a patient there at Terrell State Hospital?
She is.
Why is she in Terrell State Hospital?
He'd been found incompetent to stand trial on a charge of aggravated assault with a deadly weapon and has at this point been unable to achieve competence to stand trial.
How long has she been a patient there at Terrell State Hospital?
I'm actually unsure. I think it's been at least a year, but it may have been more.
Okay.
It's been 3 years.
And you stated at this point, her competency has not been restored. Is that correct?
That is correct.
Okay. And are you asking the court today to extend her treatment there at Terrell State Hospital in order to restore her competency?
I am.
Okay. And is it your opinion, Dr. Dunn, that if not treated, she'll continue to suffer severe and abnormal mental, emotional, or physical distress?
Yes.
And is it your opinion that if her treatment is not extended, she will continue to experience deterioration in her ability to function independently?
Yes.
And is it again your opinion that if her treatment is not extended, she'll be unable to make rational and informed decisions as to whether or not to submit to treatment herself?
Yes.
Okay, and you're asking the court today to extend her inpatient treatment there at Terrell State, is that correct?
That is correct.
I'll pass the witness, Judge.
Mr. Schmidt?
Just briefly, Judge. Dr. Dunn, it's my understanding that Khadidra, I guess we could say, came close to obtaining competency some months ago. Are you aware of that in the records?
Yes, I am. She has taken some steps forward and some steps back in that regard. In fact, I was asked to assess her competence at one point a few months ago. And at that point, she was just kind of blurting out answers that she may have memorized when she underwent competency training. But I know that Dr. Votz believes at some point that she has approached competency and for that reason had requested, I think on 2 separate occasions, her to be evaluated by the competency evaluators. But on both occasions, they determined that she was not yet able to be considered competent to stand trial.
Okay. And so while she is not competent at this time, that she is potentially on the cusp, so to speak.
That is correct.
Okay. And okay. Thank you, doctor. That's all I have.
Brian, get me out of here.
Anything else?
I just have one more question. Dr. Dunn, is it your opinion that continued inpatient treatment is in the best interest of Ms. Denson?
Yes.
Okay, I'll pass the witness.
Mr. Schmidt, any cross after that?
No, sir.
All right, anything else from the state?
No, Judge, we rest.
Mr. Schmidt?
Best, Your Honor.
All right, well then, based upon the physician certificate as well as the testimony from the medical expert, then the court finds that continued treatment of Ms. Denson may result in competency restoration, and it's in her best interest to remain in Terrell State Hospital for competency restoration. And the court's also making all the other findings in the court, or in the state's order that's been presented to the court. Anything else?
No, sir.
Not from the state, Judge.
No, sir.
All right, thank y'all for waiting, Doctor. We had to get our software updated, so we appreciate it.
Thank you, Your Honor. Appreciate it.
All right, y'all
Bye-bye.
can log off. Thank you, Mr. Schmidt. Do you have anything else, Brian?
Yes, sir. I
You do
have
have
two
some other
arraignments.
stuff?
Yes, sir.
Okay, what else you got while I've got you on there?
Judge, I have two arraignments. I have one on Frank Grayson Brown.
Okay, Frank Brown, come on up, sir. All right, this is cause number CR 21-0941-173, the state of Texas versus Frank Brown, set for arraignment. Mr. Schmidt.
Your Honor, I previously received a copy of the indictment. His name is spelled correctly. He understands the nature of the charge. We would waive the reading of the indictment and our plea of not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive two new court dates there in writing. That's December the 8th at 9 a.m. for discovery status. And then again on January 12th of 22 at 9 a.m. for pretrial. And so you'll receive those in writing. And make sure you stay in touch with your bondsman and Mr. Schmidt. And does he have conditions of bond? From September 8th? Did you receive your conditions of bond?
Yes, sir.
You do have them? Okay. I'm just making sure you understand that those are, if you have any questions about them, make sure you give Mr. Schmidt a call and go over those with you, or go over those with him. And do you have any questions now?
No, sir.
All righty, sir. We'll see you back in December.
Great, Judge, if I may.
Yeah, he's
Grayson?
coming back.
Grayson, could you drop by? Do you have two copies of that setting notice of setting?
I'll send it to you, Brian, if you'd like.
Okay, or he can drop it by the office. It doesn't matter.
He's going to
Great.
drop it by.
Thank you, Judge. Thanks, Grayson.
And, Langston next.
Yes, sir.
He may be taking a drug test. Ronald Langston, is he finished? He's in there now? Yeah, he's taking a drug test now, Brian, so we can get back to you.
I'll stand by.
All right, thank you. All right, continuing on with open announcements, Ms. Thompson.
Page 10, Christian News.
I think Miss Muse. No, Kristen Muse. Cause number CR 21-0863-173, the state of Texas versus Kristen Muse. Is there Kristen Muse in the courtroom? I see no one. I hear no answer. I don't think she answered. I didn't get an answer. There's no answer in the courtroom. Her name was called 3 times in the lobby. There's no answer. I actually called her name earlier for a drug test and she didn't answer. She's not appearing via Zoom. Time is now 9:28. She was set at 9 a.m. Notice was sent. Court will entertain a motion.
State moves for bond forfeiture.
Granted, capious issue, she'll be held with no bond. And I'm here all day if we find her.
Yes, sir.
Who else you got?
Ms. Lopez, Erica Lopez on page 10.
Ms. Lopez, come on up. These are cause numbers CR 21-0671 and 0924-173. And let's see, both of these are styled the state of Texas versus Erica Lopez, and both set for arraignment. Ms. Thompson.
Your Honor, we have received copies of indictment. Her names are spelled correctly. She understands the charges on both indictments. We'll waive the reading of any formal indictment for today's hearing and we're pleased not guilty.
All right, ma'am, the court notes you're pleased and not guilty in each of these cases. You're going to receive 2 new court dates in writing. It's December the 8th at 9 a.m. for discovery status. And then again on January 12th of 22 at 9 a.m. for pretrial. And so if you get out of jail between now and December, I need to see you here on December 8th. All right, thank you, ma'am. You can have a seat.
Yeah, I have one more case. It was
Bless
Pete Wood for
A writ?
for writ, and we're going to withdraw the writ. Mr. Wood is in there in a wheelchair. Y'all know if he can handle it from there.
You're withdrawing the writ?
We're withdrawing the writ.
Okay, well then if you're just make sure you file a non-suit and I'll take it off.
Yes, sir. Thank
All right,
you.
Mr. Wood, you understand that? They're withdrawing the writ, so. Okay,
Y'all may be excused.
yes, ma'am. Ms. Altier,
For a read, and we have also worked out a plea agreement and we're prepared to go forward on that.
she signed up yet?
Yeah.
No.
Ms. Maldonado, come on up. Said she is. It's not. Okay, we already got it. Wow, that's quick. We're going to arraign her first. So I'm going to do it in two separate hearings. Cause number CR 21-0719-173, the state of Texas versus Veronica Maldonado, set for arraignment. Ms. Altier.
Yes, Your Honor. This is Veronica Maldonado. Her name is spelled correctly on the indictment. She understands the nature of the charges. We waived the formal reading, and for the purpose of arraignment, she pleads not guilty.
All right, ma'am, the court notes your plea of not guilty. Now I'll call the case CR 21-0719-173, state of Texas versus Veronica Maldonado. Plea has been presented to the court. Is the state ready?
You are, Your Honor.
And on behalf of Ms. Maldonado,
We're ready, Your Honor.
all right, ma'am, is your name Veronica Nicole Maldonado?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for this third-degree felony offense of possession of a controlled substance?
Yes, sir.
I get you to raise your right hand the best you can, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Ms. Maldonado, can you read and write the English language? Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that? And Ms. Maldonado, have you ever been treated for any mental health or emotional issues? You understand what's going on in here today? And Ms. Altieri, do you believe your client is competent?
I do, Your Honor.
And the court finds that she is. Ms. Maldonado, I know that you were just arraigned earlier on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a third-degree felony, which carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that range? In the plea bargain?
Your Honor, we're asking the court to defer a finding of guilt for 4 years. Place Ms. Maldonado on probation, $1,000 fine, attorney's fees, court costs, and lab restitution.
Is that your understanding of the plea bargain, Ms. Maldonado? And is that your understanding, Ms. Altier?
It is, Your Honor.
Ms. Maldonado, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that document with Ms. Altier?
Yes, sir. I
And
did.
did you sign the front and the back?
Yes, sir. I did.
Do you have any questions about it?
Yes, sir.
You have to talk just a little louder, okay?
Yes, sir.
All right, we're being broadcast around the world via the interweb. All right, the next document that I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign that second page?
Yes, sir.
Do you have any questions about it?
Yes, sir.
Do you have any questions about any of the documents that you read and went over with Ms. Altier?
Yes, sir.
Well, if you read and went over these with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
Yes, sir.
Do you want to do this plea bargain?
Yes.
And I'll ask you, ma'am, how do you plead to that third-degree felony offense as alleged in the indictment? Are you guilty or not guilty? Are you pleading guilty because you are and for no other reason? You're guilty. Okay, I'll hear the evidence.
Judge has states 1 an offense report, states 2 is Michael Morton compliant, and states 3 is a lab report.
No objection.
Admitted.
The defense rests and closes. Your Honor.
All right, Ms. Maldonado, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, The court will follow the plea bargain, defer making any finding, places you on 4 years community supervision. You do have 23 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, and lab fee. And Ms. Maldonado, have you ever been on probation before?
Yes, sir.
Did you successfully complete it?
Yes, sir.
All right, well, then you know how to do that, right? Well, do you know what can happen to you if you don't successfully complete this probation?
Yes, sir.
What can happen? That's right. Here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest. You'd be brought back before the court. And if at a hearing, the court found it were true that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 10 years in prison. You understand that? So would you agree with me? It's extremely important you abide by these. I hope you do, man. Good luck to you. You need to see probation as soon as you get out. Gotcha.
I have nothing further this morning yet.
Yes, ma'am. Thank you. Mr. Stevens.
Page 9. We go on down the list and I might be on
Okay.
there.
Hey, what time did you get out of here? And we were betting you were going to be in there all day long.
I'm not sure what time I got the text message, but when I responded, I just wrapped up, which was
Okay.
like 3:30.
That's probably pretty good.
So
We
I
were
don't
making
know
bets you'd be in there all
If
day.
y'all were still there. Oh,
No, we were done. Yep. Right.
we should have, except for the attorney I was kind of dealing with was dragging.
All right, we'll start off with Mr. Rockmore. Come on up, sir.
On Tedrick, Your Honor, if we could recall, I believe
Okay.
that's a county attorney is supposed to be coming over on that. I sent a text message to Barry.
Oh, is it special prosecutor? on
It
that?
is.
All
I
right,
haven't got
sorry,
a
Mr.
res-
Rockmore. False alarm. Have a seat. We're waiting on another prosecutor.
I haven't got a response from Barry, but I'll try to call. Okay. So we'll hang out and see when they
Okay.
send somebody over on that one.
Then Jackson,
Yes.
Bobby Jackson.
Yeah, that's it. Your Honor,
Hold on, let me call him. Calls number CR 21-0535 and 0799-173. The state of Texas versus Bobby Jackson, set for arraignment. Mr. Stevens.
Your Honor, I'm trying to confirm with regards to CR 21-0535. It shows a 2-count indictment, but the indictment that I have doesn't show a count 1 and count 2. So I'm trying to see if there's an additional sheet to it. Yes, if we can just use the original. Your Honor, for purposes of arraignment, his name is spelled correctly on the indictment, understands the nature of the charges against him, waives formal reading of the indictments, enters pleas of not guilty in both cause numbers as well as not true to any enhancement paragraphs.
All right, sir, the court notes your plea of not guilty in each case for each count as well as not true. You're going to receive 2 new court dates in writing. That's December the 8th at 9 a.m. for discovery status. And then again on January 12th of 22 at 9 a.m. for pretrial. So if you get out of jail between now and December, I need to see you back here on December 8th. You can have a seat as soon as you receive the reset notice. McCusker.
Yes, sir. I believe he's in Dallas County Jail still. They won't honor a bench warrant.
Okay. What do you
He's the
want
one
to
that
do?
Has the messed up spelling of his name. I think it's the 3rd time we've come before the court. I don't know if we just want to set him off to next year or
Do you know what he's been held in Dallas for?
don't off the top of my head.
No.
It shows that he's got some low-level tickets.
Maybe he's just sitting them out, loose stare, white on one side, wheat on the other. Everybody's happy.
Well, he's sent in
That's how they make their
he
sandwich.
sent in a pro se motion for a bench warrant. And I didn't answer them. I didn't send them an email back because we had already issued a bench warrant. Figured he was ready to roll. But Johnson County Police.
Yeah, it gets me to thinking, how do you really technically, how does one court deny another court's bench warrant? If you think about that, I don't know. Let's just set him off. Let's issue another bench warrant for December the 8th. See what happens.
Yes, sir.
State, you got that?
Yes, sir.
Okay. And then, let's see, so that's McCusker, Dallas. Juan Romo?
Yes, sir.
That's set for sentencing, is that correct?
It's an agreed sentencing, Your Honor.
Okay.
This case that we tried a few months ago, and then we were coming back the next week for sentencing. He came down with COVID, been
Right.
in COVID for several settings, and what we have is, we agreed to waive the jury for sentencing purposes. State agreed to offer the minimum, which is 25 years,
Okay.
with the right of appeal. And in exchange, we're stipulating to the enhancement paragraphs. And so essentially, it's somewhat of an agreed plea without him saying it's true that he committed the two prior, or that it's true, the enhancement paragraphs are true. I think we're going to offer them, we'll stipulate, and then the court will sentence him in accordance with the agreement.
All right, hold on a second. So he's not pleading true to the enhancement paragraph?
No, sir. So we're basically stipulating to the enhancement paragraphs. They're going to be offered, we'll stipulate.
Or you're stipulating to whatever, I guess it's a pin pack you're going to introduce?
Judge, we hadn't really discussed this, but I mean, I could introduce the PIN-PACs, but I think it'd just be easier and cleaner if he just pleads true to the
Yeah,
answer.
he doesn't have to. It's his right not to.
We just have a.
Let's do this. Can y'all talk about it, kind of how you want to handle it? And I don't want to hang everybody up while we're trying to figure out how we're going to do it.
Okay, let me.
If y'all don't mind. Okay. Mr. Shackelford. Morning.
Patrick Russell.
Mr. Russi. All right, it's cause number CR 21-0777-173, State of Texas versus Patrick Russi. Set first for arraignment, and then we'll handle the other motion. So, Mr. Shackelford.
Your Honor, Mr. Russey's name appears proper both in the style and the body of the indictment. He understands the charges against him and pleads not guilty for purposes of arraignment.
All right, Mr. Russi, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates in writing. That's December 8th at 9 a.m. for discovery status, and then again on January 12th of 22 at 9 a.m. for pretrial.
Your Honor, on that January 12th date,
Uh-huh.
is there a date past that that we can I can get with the clerk?
What you got?
We're gonna do something a little different. Rest of it's just about it in this case.
So,
Yeah, I thought I just set bond on a new case yesterday on him.
yeah, so that's a CR 210956, Your Honor.
So I haven't, Mr. Russi, I haven't seen you in years. You hadn't been in a courtroom before, have you? And this is first one on this one, right?
So I'll figure out a date. I'll figure out pretty well.
Okay, so we'll just keep the December 8th date and we'll just figure it out from there.
Yes, sir. So
Now, are you urging your motion to reduce bond today?
no, we'll pass it until November
So you-
4th. We'll
okay.
come back and do the arraignment on the newly filed case, and we'll do both the motions to reduce at that time, Your Honor.
Okay, and so then we'll set this case for December 8th at 9 a.m. for discovery status, and then November 4th at 1:30 for a motion to reduce bond.
Thank you, Your Honor.
Got that, Mr. Russi? All right. If you happen to bond out before all that, November 4th. Yes, sir. Good to see you. Ms. Fallhaber. Alexis Gibson. All right, cause number CR 21-0877-173, the state of Texas versus Alexis Gibson, set for arraignment. Ms. Fallhaber.
Thank you, Your Honor. I have gone over the indictment with Ms. Gibson. Her name is spelled correctly. She understands the nature of the charges against her, waives formal reading of the indictment, and enters her plea of not guilty for purposes of arraignment.
All right, ma'am, the court notes your plea of not guilty for purposes of arraignment. Thank you. You're going to receive two new court dates there in writing. That is December the 8th at 9 a.m. for discovery status, and then again on January 12th of 22 at 9 a.m. for pre-trial. And so as soon as you receive those, you got those in writing. I also ordered you to take a drug test today. I think you've hit almost the Henderson County cycle. You've allegedly tested positive for methamphetamine, amphetamine, and THC, and allegedly admitted to smoking marijuana 2 days ago, drinking alcohol last night, and smoking meth 2 days ago. Did you drive up here?
No, sir.
Well, you're not going to drive going out of here. It's a new rule I have. And so here's what I'm going to do. You already have conditions of bond, but I'm going to tell you what they are. No alcohol, no drugs not prescribed, no illegal drugs, and no THC, Delta 8, whatever all that nonsense is. Stay away from all of it. I'm going to test you when you come back in December. And if you test positive in December, you may not go out that door. You may go out that one escorted by a deputy. Do you understand that?
Yes, sir.
All right. Now, you're too young to be doing all this. Look around at some of these other people, and you're not going to have all those teeth if you keep doing this stuff. If you need help, ask somebody.
Yes, sir.
Okay.
Thank you.
You're welcome. Christopher Smith.
Yes,
Let's
sir.
go down the line. Christopher Smith. Wanted to see her date of birth, see how young she is. She's not as young as I thought she was, but still. Yeah. All right. These are cause numbers CR 21-0091, 0092, 0789, and 0893-173. And all of these are styled the state of Texas versus Christopher Smith. Let's see, the 789 and 893 are set for arraignment. Ms. Fallhaber.
Your Honor, I have gone over those indictments with Mr. Smith. He understands the nature of the charges against him. His name is spelled correctly, waives formal reading of the indictments, and enters his plea of not guilty for purposes of arraignment.
All right, Mr. Smith, the court notes your pleas of not guilty for purposes of arraignment on these two cases. And let's see, I'm going to set the two new cases for December 8th at 9 a.m. for discovery status, and then again on January 12th of 22 at 9 a.m. for pretrial. And I'm just going to reset those other two cases for December the 8th as well. And that way they'll all run at the same time. Okay, Mr. Smith? All right, hold on a second. You gotta get those in writing. Also, if you get out of jail between now and December, I need to see you back here on December 8th, okay? Thank you, sir.
Lyle Vandiver.
Lyle Vandiver. It's cause number CR 21-0945-173, the state of Texas versus Lyle Vandiver, and that is set for arraignment. Ms. Fallhaber.
Thank you, Your Honor. I have gone over the indictment with Mr. Vandiver, and his name is spelled correctly. However, he would like for me to point out to the court that the caption lists him as a white male, and he is not white. He is,
Okay.
So he waives formal reading of the indictment, enters his plea of not guilty for purposes of arraignment.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive two new court dates there in writing. It is December the 8th at 9 a.m. for discovery status. And then again on January 12th of 22 at 9 a.m. for pretrial. So if you get out of jail between now and then, I need to see you here on December 8th. And can I see the indictment? Which tribe?
Navajo Nation.
Okay. And I'll even write it, even though it doesn't affect the indictment, I totally understand, and I will scratch it out and write it.
Your Honor, the last one I have is Sonny Vaughn, however, I believe he's still taking his drug test.
Okay. I wrote it on the indictment.
Thank you.
You're welcome. Mr. Stevens?
We're ready now on Mr. Romo.
Okay.
Well, if we can offer him, just to be clear, since
Oh, let's see, officer. The only problem is when you do a pin pack, then I got to get somebody here to print them and I'm going to have to compare them. And if I don't, then that's insufficient evidence. I would think. Because normally when I plead not true, you get the pin packs, you got to file a motion to fingerprint the defendant, you fingerprint him. And then you have to have an expert come in here and compare the two prints and say, yeah, that's the same guy.
that's fine, Your Honor. We're agreeable to plead true.
Okay. All right. This is cause number CR 20-0510-173, the state of Texas versus Juan Francisco Romo. And this is set for a sentencing hearing today. Can I see the docket sheet? That's one with the good record. All right, let's see. Mr. Romo was actually set for sentencing on September the 9th. However, he was in quarantine. He was set for sentencing. Trying to find the date, sorry. He was set for sentencing after a jury of his peers found him guilty unanimously beyond a reasonable doubt on August the 23rd. And so the court impaneled a jury. A jury was selected on that same date. Both sides presented evidence. The jury was sent to deliberate. The jury again found him guilty beyond a reasonable doubt on that same day. The court ordered a PSI and set it for sentencing, and that sentencing was continued based upon a quarantine until today. And so now the court has been presented with an agreed sentencing recommendation, and is the state ready?
We are, Your Honor.
And on behalf of Mr. Romo?
We're ready.
All right, Mr. Romo, a jury has already found you guilty beyond a reasonable doubt. However, I am going to go over this paperwork with you, almost like it was an original plea, so just bear with me. Sir, is your name Juan Francisco Romo?
Yes, sir.
And are you the same person that was indicted by a Henderson County grand jury and convicted by a Henderson County petit jury for this felony offense?
Yes, sir.
If I can get you to raise your right hand the best you can, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Romo, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain on sentencing with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Romo, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here? And Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
And the court finds that he is. Mr. Romo, I know that you've been arraigned on this case, and the indictment was also read out loud in front of you and the jury during your jury trial. However, would you like the state to read the indictment as well as any enhancement paragraphs?
No, sir.
But do you understand them?
Yes, sir.
All right. And well, Mr. Romo, the range of punishment for the underlying offense, a second-degree felony, is not less than 2 years nor more than 20 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that range?
Yes, sir.
However, the state has alleged 2 enhancement paragraphs, which, if found true, would make that punishment range not less than 25 years or more than 99 years or life and a fine of up to $10,000. Do you understand that range?
Yes, sir.
In the sentencing recommendation?
Your Honor, it's 25 years confinement in TDC with credit for 410 days served, plus attorney's fees, court costs, and live restitution. We're also asking the court to consider and dismiss an unfiled misdemeanor possession of marijuana on October 1st, 2019.
Is that your understanding of the plea bargain, Mr. Romo?
Yes, sir.
Is that your understanding, Mr. Stevens?
It is, Your Honor.
Mr. Romo, a few minutes ago, you told me you could read and write the English language. I'm going to go over a couple of documents with you. Well, actually, I'm just going to go over one. It's the agreed sentencing recommendation. Did you read and go over that with Mr. Stevens?
Yes, sir.
And did you sign the front?
Yes, sir.
Did you read and go over the back with him?
Yes, sir.
And did you sign the back?
Yes.
Do you have any questions about it? You have any questions about any of the documents that you read and went over with Mr. Stevens?
No,
All right, well, if you read and went over these with him, I know he explained to you that you don't have to do this. You could actually have a sentencing hearing, which is what we're set here for today. And at that hearing, you could do better or worse in this 25 years. Do you understand that?
Yes, sir.
All right, do you want a hearing? And when I say better, if I didn't find these enhancement paragraphs true, then the punishment range would be 2 to 20. If I only found one of them true, the punishment range would be 5 to 99 years or life in that same $10,000 fine. Or it could be worse. I could find them both true based on the evidence, and you could do a lot worse than the 25.
I am the person that was.
Okay, hold on a second. I gotta go through this piece by piece. Do you want a contested hearing, or do you want to go through with the plea bargain? All right, well, I'm going to ask you, sir, as to these two enhancement paragraphs, is it true or not true that in February of 1999 in Cleburne County, Texas, you were finally convicted of the felony offense of possession of marijuana?
Yes, sir.
Is that true?
Yes, sir.
And are you pleading true because it is true and for no other reason?
Yes, sir.
And is it also true that after that conviction was final, you were convicted of felony driving while intoxicated in August of 2013 in Ellis County, Texas? Is that true or not true?
Yes, sir.
And are you pleading, we got to tell me true or not true?
That's true.
And are you pleading true because it is true and for no other reason?
Yes, sir.
I'll hear the evidence on punishment.
Judge, I have 2 pen packs. I'm not sure how you want me to mark these.
No, the signature in the file. So that's what I meant.
You gonna open it? She's, no? I got it. I don't carry a knife. I carry a gun. All righty. Why don't we just introduce them as punishments, exhibits 1 and 2?
That was for the state of the worker. Ms. Forbes.
Here's what we'll do. I'm going to conditionally, I'm going to admit them with, is there any objection?
No objection.
I'm going to admit them, and whatever exhibit numbers they are, then we will mark them with the appropriate exhibit numbers, keeping in numerical order from guilt innocence.
So in that case, Judge, I'd offer 2 certified copies of pen packs from TDCJ.
No objection.
Admitted.
State rests.
If I may briefly call my client, Your Honor.
Yes, sir. He's under oath.
Please state your name for the record. And I know you had some hesitation when the court was talking to you about that you could do better than this or you could do worse. And we talked about the punishment phase of this case. And you understand that if the judge was to find the enhancements true, that the best that he would be able to sentence you to is the minimum in this case, which is 25 years. You understand that? If he finds the enhancement paragraphs true. But if he finds those true, you understand that you could also do significantly worse than the minimum that's been offered to you in this case. Is that correct?
That is correct.
And so essentially, we've reached an agreement with the state that the state's willing to offer you the minimum punishment in this case based on the 2 prior enhancements. Is that correct?
That's correct.
And in exchange, they've also allowed us to preserve our right to appeal should you wish to have an appeal filed with regards to the guilt innocence phase of this trial. You understand that? And so is it your understanding, or is it your wishes to go ahead with that agreement and waive your right to the judge considering those enhancement paragraphs and accept the offer that's been made in this case?
Yes, sir.
You understand that by accepting the offer, it doesn't negate your right to file an appeal as it relates to the guilt innocence phase of this case, correct?
Correct.
I'll pass witness.
No questions, Judge.
Rest
Anything
is
else?
closed.
All right, then, Mr. Romo, first of all, the jury, having found you guilty back in August of this year, beyond a reasonable doubt, the court accepts that jury's verdict and also finds you guilty. The court will follow the plea bargain, finds the enhancement paragraphs based upon the evidence and your pleas are true, finds both enhancement paragraphs true. The court follows the recommendation, sentences you to 25 years in the Texas Department of Criminal Justice, considers the misdemeanor marijuana in sentencing you. You do have 410 days credit as to any sentence you may eventually have to serve, and orders you to pay your attorney's fees and court costs as well as that lab fee. And Mr. Romo, you do have a right to appeal. Can you make sure that he fills out that the paperwork today?
Yes.
And before you go, Mr. Romo, I had it here with me. Did you get an opportunity to review the judgment in your case?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
All right, sir, you're now remanded back to the custody of the sheriff. Transport to TDC to serve out your sentence. Good luck to you, Mr. Romo. All right. Mr. Scott.
Jesus Mancia, page 7. For arraignment and a bond reduction.
We're reigning first. All right, this is cause number CR 21-0758-173, the state of Texas versus Jesus Mancia, and set for arraignment, Mr. Scott.
Yes, Your Honor, I got a copy of his indictment. He understands the nature of the charges against him and will waive formal reading of the indictment and enter a plea of not guilty to both counts in the indictment.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates there in writing. That's December the 8th at 9 a.m. for discovery status. And then again on January 12th of 22 at 9 a.m. for pretrial. So I don't know what's going to happen on the motion to reduce bond, but either way, if you get out of jail between now and December, I need to see you back in the courtroom on December 8th at 9 a.m. All right, and now are you ready on this motion to reduce bond?
Yes, Your Honor.
And are we going to hear testimony from your client for the limited purpose of bail?
Yes, Your Honor.
Right, sir, if you could raise your right hand the best you can. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand, Mr. Scott.
Mr. Mancia, you're here, you've been in the custody of the Henderson County Jail since September the 24th, is that right?
Yes.
And you were actually living down in Brownsville, Cameron County, and you were arrested down in that area, is that right?
That's right.
And how did you come about being arrested?
I was coming from Mexico to Brownsville.
You have family down
I
there.
got family down there, I was visiting over there and I got arrested.
Okay, so I guess they ran you and found that you had a warrant.
Yes.
Is that the way you found out that you had a warrant?
Yes,
You'd had no knowledge before that?
I didn't know my.
Okay, so they took you to the Cameron County Jail and that was on August the 16th, is that correct?
That's correct.
And did you find out that you had a couple of $250,000 bonds on you?
Yes,
And now you've been here for almost, well, not quite a month, but you haven't been able to make bonds in your cases, correct?
yes.
Do you have the kind of money it would take to make $500,000 worth of bonds?
I don't know.
No. In fact, you think that you could come up with about $3,000 total, is that right?
That's correct.
And you've got some friends and family that could probably get it a little bit higher, correct?
Yes.
And we were talking about what amount you thought you could do reasonably, and you were thinking maybe $20,000 on each charge.
That's correct.
So a total of $40,000.
Yes.
And do you live there in Brownsville?
Yes.
How long have you lived there?
I've been back to Brownsville since 2018.
Okay. And you have a relative there, your mother, correct? Do you live with her?
I live with my mom.
Okay. And she is older, correct?
Yes.
And has some health issues?
She got health issues.
Okay. And so you're kind of
I'm the household of the house.
okay. And you help your mom.
Yes.
She can't see, is that what you
That's
told me?
correct. She lost an eye, and a couple of weeks ago, she fell. Another eye.
And these charges you have, these are, you weren't arrested on them at the time they were alleged to have occurred, because these were some assaults that were alleged to have occurred between you and some detention safety officers in the Henderson County Jail.
That's correct.
So you weren't arrested at the time, you just were, warrants were issued based upon the indictments in this case, correct?
Yes, sir.
Okay, so you're asking the court to reduce those bonds to a total of $40,000, and you understand you'll have to come to court
Yes.
on your future court settings, which we have here in writing.
Yes.
Do you have a way to get here? Do you have reliable
Yes, I
transportation?
do.
Okay, and you promise to appear for all court charges?
Yes.
Okay, I'll pass the witness, Sharon. Oh, sorry, I forgot to ask.
Okay.
And you were working at one time before your arrest as a welder.
Yes, I was working at SpaceX as a welder down in Boca Chica in Brownsville, Texas.
And you've been a welder since 2009,
Yes, that's correct.
certified welder?
Certified welder, yes.
Okay, so it's pretty easy for you to get a job.
Yes.
Do you anticipate getting a job if you can get released?
Oh, yes.
Okay, I'll pass the witness.
Mr. Mencia, so you were arrested at the border on the warrants for these two offenses, correct? That's correct. What were you in the Henderson County Jail for in the first place? We got transferred from Orange County because of the hurricanes last year. Okay. All right. And you said you have family in Mexico. Where in Mexico? Matamoros. Okay, that's just over the border, right? Okay. You ever lived in Louisiana? Yes, I have. Okay. Did you pick up any criminal history in Louisiana? Yes, second. We'll pass the witness.
No further questions, Your Honor. We just asked the court to consider reducing these bonds to 20,000 on each count.
Mr. Cox, anything?
Judge, his criminal history, he has a conviction for tampering with government record out of Orange County, which is why he was in our jail in the first place, as testified to. He also has convictions for DWI, possession of marijuana, bail jumping. And as he stated, I show some criminal history in Louisiana, but I'm not sure what.
Okay. All right. Anything about that? Mr. Scott?
No, Your Honor.
All right, well then, based upon testimony as well as the current conditions, well, by his own admission, he does travel to Mexico. Right now, the federal government's refusing to, is unlawfully refusing to enforce border law, and therefore he is a flight risk. He does have a bail jumping conviction, and so the motion is respectfully denied. Bond will remain at 250,000 surety on each.
You got that order there, Your Honor?
Yes, sir.
Thank you, Judge. And that's all I had this morning. If I can be excused to this afternoon.
Yes, sir.
Thank you.
Ms. Fallhaber.
Thank you. I've got Sunny Vaughn, I believe it's on page 2.
Mr. Vaughn, come on up. Did you take a bill? Oh, I got him right here. All right. This is cause number CR 21-0842-173, the state of Texas versus Sunny Vaughn. And that is set for arraignment. Ms. Fallhaber.
Thank you, Your Honor. I've gone over the indictment with Mr. Vaughn. His name is spelled correctly. He understands the nature of the charges against him, waives formal reading of the indictment, and enters his plea of not guilty for purposes of arraignment.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. And you're going to receive 2 new court dates there in writing. That is December the 8th at 9 a.m. for discovery status. And then on January 12th of 22 at 9 a.m. for pretrial. So as soon as you receive those in writing, you're free to go. You did test negative, but I did place conditions of bond on you. No alcohol. I did that when I signed bonds for arraignment. For grand jury, no alcohol, no illegal drugs, no drugs not prescribed, and no THC, marijuana, or any of that, which you shouldn't have a problem with. All right, we'll see you in December.
Can I be excused until this afternoon?
Yes, ma'am.
Thank
Thank
you.
you. Mr. Skelton?
We have page 8.
Mr. Stacks. All right, this is cause number CR 21-0882. Correction, CR 21-0873-173, the state of Texas versus Lester Stacks. And so it's set for arraignment and a motion to reduce bond. Let's do arraignment first.
All right. And you're Lester Stacks? Yes. All right. Now, you have seen a copy of the indictment? Yes. We discussed it. Is your name spelled correctly in the indictment? Yes. You understand, you received the copy and you understand what it means. So do you waive the reading of the indictment? Yes. All right. And do you plead not guilty? Yes. All right. That's all we have on this one.
All right, and then Mr. Stacks, court notes you pleaded not guilty for purposes of arraignment. You're going to receive 2 new court dates there in writing. That's December the 8th at 9 a.m. for discovery status. And then again on January 12th of 22 at 9 a.m. for pretrial. And so whatever happens with this motion to reduce bond, if you get out of jail between now and December, I need to see you back here on December 8th, okay? All right, and now are we ready for the motion to reduce bond?
Yes, Your
And are we going to hear testimony from your client for the
Yes.
limited purpose
Honor.
of
For
bail?
the purpose, yes, Your Honor.
All right, sir, if you could raise your right hand the best you can. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And you can lower your hand. Mr. Skelton.
State your name, please, sir, for the court.
Lester Stacks.
Mr. Stacks, where do you live permanently?
I can't hear him.
Speak up louder, would you, please, sir?
Can't hear you.
With Mario Perron.
All right, now.
Hold on. Where does he live?
He lives with a man named Mario.
Geographically speaking, where does he live?
He lives in Athens.
Okay.
I was gonna get to that next. You've always lived in Athens, haven't you?
Yes,
Now, you were born in Athens.
yes,
In your entire adult life, you have never lived any place except Athens, have you?
no,
Your father was a member of the school board here in Athens.
yes,
You went to Athens School,
yes,
graduated from Athens Schools.
yes,
Now, are you aware that the court has set your bond for $75,000?
yes,
Now, you were arrested on this matter first before you were indicted, were you not?
yes,
And was the bonds set at $8,500 then
yes,
for possession of controlled substance or methamphetamine less than 1 gram?
yes,
And did you make that bond?
yes.
How long, when did you make that bond, if you recall? About what?
Like 3 weeks. Check it out.
All right, and so were you out on bond then for a considerable length of time?
Yes.
All right, so then you were indicted,
Mhm.
right? And then when the indictment, your bond was then set at $75,000.
Yes,
All right, and before you were indicted, and the bond was set at $75,000 in your jail, did you ever fail to report on the first bond?
no,
Okay, now, you have, if the court were to lower your bond, may I ask you this, if the court were to lower your bond to $8,500 or $7,500, $6,500, in that range, could you make a bond?
yes.
And how would you do that?
cash. Okay, do you have the cash? Do you have the cash to do that? I can get it together. You can get it together? Okay. Would you be able to get any more than, I guess you're talking about $1,000, is that right? Yes. Yes. Would you get any more together than that? Yes, sir. Okay. Now, if the court were to lower your bond or reduce your bond to the point so that you could make it, and you were to get out, what would you be doing in terms of occupation, trade, or what? Landscape. And have you done that before? Is that just something made up before? No, it's been years. Okay, now you mentioned Mario Padron. Is he who you work for, or is he an employer or a contractor with you, or what? How does he work? Well, he's an employer. How long you worked with him? 9 years. 9 years, all right. Now you understand if the court will lower your bond, you will make it, you're gonna show up. Yes. Do you have any relatives or any connections out of state? Or anywhere in the state outside of Henderson County? All right, you understand one of the conditions of bond is going to be that you probably wouldn't be driving. And the other one is that you not use harmful substances or controlled substances. Yes. You follow that? Yes. Now, you've been in jail this time how long? Yes. Over a month and a half. Okay, so right now whatever the situation was, you're clean and sober right now. Yes, sir. Okay. And you think you can remain that way? The judge will allow you to give you an opportunity to get out of jail? Yes, sir. Okay. Now, one final thing, even though you grew up here in Athens, do you have any immediate family or any family at all, like a blood family here in Athens? Yes. And who is that? My brother. And is he that you used to live with him right now? Yes. I think you are. Sorry, I apologize. My phone.
Mr. Stacks, Mario Padron, does he have any criminal history that you're aware of?
No.
Does he use drugs?
No.
Okay. Now you said you can get together about $1,000 cash, is that right?
Yes.
Where's that going to come from?
I got a separate fellow mower and a couple more things that I can sell.
Okay. You can get a property you can sell?
You know,
Automobile?
probably so.
Okay. And you were arrested with a guy named Matt McKee's, is that right? Is he any criminal history that you're aware of?
I believe he does.
Does he have any drug history that you're aware of?
No, he just was an acquaintance.
I'll pass it to this judge.
Do you know in fact Mr. Constable was not arrested, was he? No, he was just arraigned. I mean, he was a little over. As far as you're aware, he's never been charged with anything. Is that correct?
I don't need to hear any more about this. Okay, I don't need to hear any more about Mr. Pons.
Yeah.
Ponce.
Spelled Ponce, I believe.
Anything else?
No, Your Honor.
The
State.
court one here is criminal history.
Sure.
Judge, he has 2 convictions for assault, a state jail possession of marijuana, 3 thefts, PCS, possession of a dangerous drug, and fraudulent use.
Those are all convictions.
Yes, sir.
All right, well then respectfully, based upon the safety of the community, the motion to reduce bond is denied. Bond will remain where it's at. Yes, sir. Good, you need a break?
Any other, one I have to ring with Mr. Rand?
Well, let me get them by. Jerry Wren. All right, this is cause number CR 21-0882-173, the state of Texas versus Jerry Wren, set for arraignment today. Mr. Skelton.
Mr. Rennie, have you seen the indictment against you?
Yes, sir.
Is your name spelled correctly on the
Yes.
indictment? After discussing the indictment with me and reading, do you understand what you're charged?
Yes, sir.
According to you, you don't wish the court to read the indictment out loud, so you waive the reading of the indictment, is that correct?
Yes.
And do you enter your plea of not guilty?
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You can receive two new court dates in writing. That is December the 8th at 9 a.m. for discovery status, and then again on January 12th of 22 at 9 a.m. for pretrial. So you can receive those in writing. You did take a drug test today. You apparently have tested positive for THC and allegedly admitted to doing that on September 14th. And Mr. Wren, I'm going to place conditions of bond on you. You already had conditions of bond placed. I'm just going to tell you what they are. No alcohol, no illegal drugs, no drugs not prescribed, and no THC, marijuana, or any of that synthetic nonsense, okay? All right. Marijuana is a way of life, not an addiction. And you just need to find a new way of life. It's a choice. I'll see you back in December, and I'm going to drug test you again. If you test positive that time, you may go out that door, not that one. All righty.
Thank you, Your Honor. May I
Yes, sir.
excuse?
Good seeing you. Yes, sir.
Good being here.
I'm going to handle Mr. Mills, and I'm going to take a break real quick. Or Brian, are you ready on anything? Didn't you have something else?
Judge, I was waiting on Mr. Langston to take a drug test. I don't know if he's taken that yet or not.
Yes, he has.
Well, we need to arraign him. That's what we're
Okay.
waiting on.
And then Mr. Mills, I'll get to you right next. Mr. Langston, come on up. It was negative.
Thank you, Judge.
All right, this is cause number CR 21-0876-173, state of Texas versus Ronald Langston, and that is set for arraignment. Mr. Schmidt.
Your Honor, I actually don't have a copy of the indictment. I expect to be in court today. His name is spelled RONALDLANGSTON. Excuse me. He does understand the nature of the charges. We would waive the reading of the indictment, enter a plea of not guilty.
All right, Mr. Langston, the court notes your plea of not guilty for purposes of arraignment. The prosecutor there is handing you two new court dates there in writing, December 8th at 9 a.m. for discovery status, and again on January 12th of 22 at 9 a.m. for pretrial. You do have conditions of bond, which shouldn't be a problem since you tested negative. No alcohol, no drugs, no illegal drugs, and no THC or marijuana or any of that other stuff, okay? Sure. All right, we'll see you back in December.
Ron,
Sure.
I don't know if Ashley got a hold of you this morning, but could you swing my copy by the office? I couldn't be in there today.
Okay. Yes,
Did
sir.
they give you two copies? Okay, thank you.
Yes, sir.
Thanks, Ron.
Sure, thank you.
Judge, may I have excused till
Yes, sir,
1:30?
appreciate it.
Judge, I also have Van Zandt County at 1:30. Do you want me to do them first, then jump on, or how do you want me to handle that?
However you want to handle it, we'll be here a while, so whatever.
Okay. Thank
And
you.
I'm just going to leave, I'm going to leave my Zoom up through lunch.
Okay, thank you.
All right, thank you, sir.
Bye.
Mr. Mills.
Yes, sir. I'm ready. I've got
Good.
Thomas Paul Harrington for arraignment.
Mr. Harrington. Mr. Mills live from the travel trailer. I lived in one of those for 6 months. I know what they look like.
You recognize the curtains.
Right, that and the little shelves up above right there.
Oh, okay.
Puff lighting. And let's see. What is Mr. Harrington? All right, it's cause number CR 21-0934-173, the state of Texas versus Thomas Harrington, set for arraignment. Mr. Mills.
Your Honor, I've received a copy of the indictment. Mr. Harrington's name is spelled correctly in the indictment. We'll waive formal reading of the indictment, enter plea of not guilty to the charge.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. I'm going to receive two new court dates in writing from the prosecutor there. That is December the 8th at 9 a.m. for discovery status. And then again on January 12th of 22 at 9 a.m. for pretrial. And so if you get out of jail between now and then, I need to see you back on December 8th.
Yes, sir.
All right, thank you.
Gregory Thomas.
Gregory Thomas. These are cause numbers CR 21-0747 and 0897-173, both styled the state of Texas versus Gregory Thomas and both set for arraignment. Mr. Mills.
Your Honor, I've received a copy of both indictments. His name is spelled correctly in both the indictments. He understands what the charges are. We'll waive formal reading of both charges, enter pleas of not guilty and not true to the enhancement paragraphs.
All right, Mr. Thomas, the court notes your plea of not guilty and not true to each case for purposes of arraignment. Going to receive two new court dates in writing. That's December the 8th at 9 a.m. for discovery status. And again on January 12th of 22 at 9 a.m. for pretrial. So as soon as you receive those, you can have a seat. And if you get out of jail between now and December, I need to see you back here on December 8th. Sir, you're welcome.
Jeremy Fee or Phi.
Jeremy Phi, Phy. I called that name earlier and didn't get an answer. This is cause number CR 21-0886-173, the state of Texas versus Jeremy Phi. Is there a Jeremy Phi in the courtroom? I see no one. I hear no answer. He's not appearing via Zoom. I called his name a little after 9. I didn't hear an answer. I'm letting the bailiff check the lobby now. All right, his name was called 3 times in the lobby. He's not there. The court will entertain. The time is now 10:27. Arraignment was set for 9 a.m. He was sent notice. The court will entertain a motion. Granted, capious will issue. He'll be held with no bond. And again, I'm here all day. We find him.
I have a Robert Alanis.
Robert Alanis. Robert Alanis. Is there Robert Alanis in the courtroom? I see no one. I hear no answer. He is not appearing via Zoom. Mr. Alanis appears to have a number of warrants. Well, just 2 warrants, a couple anyway. All right, his name was called 3 times in the lobby. There's no answer. The time is now 10:28. He was set for 9 a.m. Court will entertain a motion. Granted, capious will issue. He'll be held with no bond.
And Your Honor, I had one more, maybe, I think,
We have
Leela
2 more,
Parks.
Aureliano Armez and James Carnes.
We pled James Carnes yesterday or day
Okay.
before.
And then Layla Parks
Yes,
and
yes.
Aurelia Armez. Which one you want to do first?
Miss Parks is fine.
Ms. Parks. Come on up, Ms. Parks. See your attorney right there. All right, this is cause number CR 21-0881-173, the state of Texas versus Layla Parks, set for arraignment. Mr. Mills.
Your Honor, I received a copy of the indictment. She understands what she's charged with. We'll waive formal reading of the indictment and plead not guilty.
All right, ma'am, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates in writing. That's December the 8th at 9 a.m. for discovery status. Then again on January 12th of 22 at 9 a.m. for pretrial. And so we've also court ordered you to take a drug test today. You did test positive for THC and admitted to smoking marijuana about 10 days ago. And Ms. Parks, you do have conditions of bond, no alcohol, no illegal drugs, no drugs not prescribed, and no marijuana, THC, any of that synthetic nonsense.
Okay, Your Honor.
Right, and that's like I told the other gentleman, smoking marijuana is a choice. It's not an addiction. It's just a way of life. You're gonna have to find something else.
Okay,
All right, I'm gonna test you again when you come back in December.
All righty, thank you.
All right, stay in touch with Mr. Mills. See you.
I sure will.
Thank you, ma'am. You're free to go.
Thank you.
And then you've got Armas.
Yes, sir.
Armas. Aureliano Armas. Come on up, sir. There's Ms. Parks too. All right, it's cause number CR 21-0930-173, the state of Texas versus Aureliano Armas. Set for arraignment, Mr. Mills.
Your Honor, I've received a copy of the indictment. He understands what he's been charged with. We'll waive formal reading of the indictment and plead not guilty.
Sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates there in writing. That is December the 8th at 9 a.m. for discovery status, and then again on January 12th of 22 at 9 a.m. for pretrial. And so you do have conditions of bond, no alcohol, no drugs, no illegal drugs, and no marijuana, THC, or any of that synthetic stuff, okay? Shouldn't be a problem because you tested negative. All right, sir, we'll see you in December. Stay in touch with Mr. Mills. Free to go. I think that's all you got, James.
That's it. Thank you, Judge. I think I've got something this afternoon, so I'll see y'all then.
Okay, we'll see you.
Thank you.
Off the record, yeah.
We have Patrick Rockmore. I talked to the county attorney's office, who is special prosecutor on the case. He pled out on a robbery charge on 9/7. The
Okay.
case that's before the docket, they told me was taken into consideration with that plea, but somehow it's still on the docket today, so they believe it should be in the clerk's file that this
I
charge
think I kind of remembered something
was
like
taken
that.
care
Because
of.
when I saw him in here, I thought, didn't he just?
Yeah, they pled 9/7 on a robbery charge, and this should have been considered with that plea.
Well, there ought to be a 1245 letter in there.
Yeah, I
Well,
believe it's
no, it wouldn't be a
1240.
12 because he's a special prosecutor.
So the county attorney wanted to know if they need to be brought over. If not, I told them we could have them submit whatever document the clerk would need to clear this case off of them. But whether they just dismiss, I don't know.
I mean, I think if it's not in the plea papers, and I kind of remember,
They said they thought it was in the plea papers. They looked on Odyssey or.
but they never gave a dismissal. Let's need to follow up with the dismissal.
Dismissal order. Okay, I will let them know to submit a dismissal order, and that'll take care of Mr. Rockmore.
That'll take care of you, Mr. Rockmore. As soon as they give me that dismissal, I'll sign it. One more. That's Justin Hunt, who doesn't have a lawyer. Is that right? Then I got to do these others. All right, if you hear your name called, let me know you're here. Well, I'm just gonna do it one at a time. Dustin Harris. Sir, did you take your drug test already? Why wasn't he ordered to take a drug test? Because he wasn't here when I called your name. Sir, do you have an attorney? Come on up. This is cause number CR 21-0778-173, the state of Texas versus Dustin Harris. Mr. Harris is set for arraignment and he's here without an attorney.
I'll ask for less time, I ask for more time. And I'm getting paid on the job, and I'm almost done with it. And I should be paid by Friday, but I'm just asking for 7 more days.
Did I drug test him the last time? And was it negative or positive? Okay, all right, Mr. Harris, I'm gonna order you to take a drug test today. Go take that test. When you get done, come back in the courtroom. We'll go over the results together and we'll finish talking. Don't go anywhere else. Justin Hunt. Oh, you're appointed? Has he taken a drug? Yeah, he has. I got it right here. I've got it. All right, it's cause number CR 21-0847-173, the state of Texas versus Justin Hunt. Set for arraignment, Mr. Stevens.
Your Honor, for purpose of arraignment, his name is spelled correctly on the indictment, understands the nature of the charges against him, waives formal reading of the indictment, enters plea of not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates in writing. That's for December the 8th at 9 a.m. for discovery status. And then we'll see you again on January 12th of 22 at 9 a.m. for pretrial. I did order you to take a drug test. You've tested positive for methamphetamines, amphetamines, and THC, and admitted to smoking the following or those things on 10/10. You didn't drive, did you? Okay, don't you drive out of here. And so you do have conditions of bond, no alcohol, no drugs, no illegal drugs, and no THC or marijuana or any of that other nonsense, okay? All right, and so I'm gonna test you again in December, and if you test positive that date, you may go out that door, not that one. If you need help, ask. There's a lot of it out there. See you in December, sir.
And that'll conclude my business.
Yes, sir. Appreciate it. And then, did I already forfeit the bond on LeVar? Andy LeVar, LIVAR, Andy LeVar, cause number CR 21-0829-173, the state of Texas versus Andy LeVar. Is there a Mr. LeVar in the courtroom? I see no one. I hear no answer. He is not appearing via Zoom. Can you also call a Carrie Shaw and Andy LeVar? CR 21-0936-173, the state of Texas versus Carrie Shaw. Is there a Carrie Shaw in the courtroom? I see no one. I hear no answer. They are not. There's no Carrie Shaw appearing via Zoom. Carrie Shaw, maybe a female. All right, each of their names, both Andy LeVar and Carrie Shaw's name, have been called in the lobby 3 times. There is no answer. The time is now 10:37. Each of them were set for arraignment at 9 a.m. They each have bondsmen, and so the court will entertain a motion on each one.
Statements for bond forfeiture on each.
Granted, capias will issue on each, and each of them will be held with no bail. Okay. So all we're waiting on is Mr. Harris. We're done with the inmates. I'll be here. God willing, and the creek don't rise. Oh, man. I'm so sore. Oh. What are you complaining about? So, yeah, he really wanted them reset notices, didn't he?
Brian?
Yeah.
Man, she's got 1:30. Here. No, it's we're just. They won't be over here. No, they can't hear me anyway. Until I'm.
We can hear you, sir. You need to mute your microphone. All right, we're going to go ahead and take open announcements on the 1:30 docket. Just some administrative notes first. If you want to wear a mask, wear a mask. If you don't want to wear a mask, don't want to wear a mask, regardless of your vaccine status or whether or not you have natural, hard-earned lifetime immunity. And with that, yes, sir.
Page 3, Brandon Black.
Brandon Black.
It was my understanding from a phone call I received yesterday that he's still in the hospital with Baylor, but I called, I could not confirm. I'll leave it to the court's judicial.
Can I see the docket sheet? Where was he the last time? It seemed like we hadn't had this
He
case.
was the first, we missed one because he went to the hospital for a COVID diagnosis. They claim he's in the hospital. I can't confirm.
Okay. All right. This cause number CR 21-0005-173. State of Texas versus Brandon Black. Is there a Brandon Black in the courtroom? I see no one. I hear no answer. There's not a Brandon Black appearing via Zoom. Let's call his name. All right, his name's been called 3 times in the lobby. The time is now 1:32. The docket was for 1:30. Court will entertain a motion.
Statements for bond forfeiture.
Granted, capious issue, he'll be held with no bond. And Mr. Harden, if you can get proof or get him,
I understand
just
that.
let me know. Yes, sir.
I did my best to confirm.
I got you. Appreciate you. Good to see you. Yes, sir. Mr. Stevens.
Page 10, I believe, Justin Paul. What I would like to do, Your Honor, is if we could have a short little hearing on the bond hearings and then take up my motion to withdraw. Motion to withdraw is based on the fact that I represent the co-defendant previously.
I got you. All right. These are, let's see.
The one's a writ and one's indicted, so it's a bond reduction.
I got you. All right, CR 21-0780-392 and the state of Texas versus Justin Paul and CV 21-0556-173 ex parte Justin Lee Paul, and both set for bond reductions just in different formats. And so are we going to hear testimony from your client for the limited purpose of bail?
Yes, sir.
All right, Mr. Paul, if you can raise your right hand the best you can. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. Mr. Stevens.
Please state your name for the record. If you could speak up just a little bit, she's got to type everything you say. Now, you currently have one charge that's indicted, which is a possession of a controlled substance less than a gram. Is that correct? And that bond is currently set at $25,000. Is that correct? You also have an unindicted charge of unlawful possession of a firearm, and that bond is currently set at $10,000. Is that correct? Yes, sir. And how long have you currently been incarcerated now? About 2 months. About 2 months now. Yes, and in that time, have you been able to come up with the funds in order to post these bonds? No, sir. Do you have any property of value that you could sell in order to post these bonds? No, sir. Do you have any money in the bank, savings account, CDs, 401k, anything of value that you could cash in order to post this? No, sir. If you were to be released, where would you be residing at? My grandmother's house. And where is that located? Okay, so and that's here in Henderson County. Yes, if you were to be released, do you have any job opportunities? Yes, sir. And can you tell the court briefly what you do for a living?
When I was training horses for a living. I just got out of prison a couple of years back, and I was working for a family member on his land, but he passed away a couple months ago.
Okay. And what type of job we potentially have once you're released?
I imagine I will go back to try to get my job. I'm going to work at a Clayton House.
Clayton Homes, and that's here in Athens, working on the building of the structures and things. Are you willing to abide by any conditions of bond that this court would place on you? Including random drug testing, reporting to the probation department, anything of that nature?
Yes, sir.
I'll pass it, Sean.
Isn't it true that the new offense that you're being charged with, that your attorney just mentioned, was when you were out on bond on the previous case?
Yes, ma'am.
Okay, and isn't it true that in the previous case, there's actually 2 counts? One is for PCS, 1 to 4 grams, and the other is for tampering.
Yes, ma'am.
Nothing further, Your Honor.
State?
The state would just like to argue because of the criminal history and the fact that these are enhanced, so that it's not necessary to reduce the bond at this time.
So he's arrested on 2 felony charges. He bonds out and then he picks up this latest, what's the latest one?
Unlawfully possessing a firearm by felon.
And he's, are there 2 enhancements alleged in the indicted felony?
There are, Your Honor.
And that would make this 25 minimum if proven true?
Yes, Your Honor.
All right, well then respectfully, based upon the defendant's prior criminal history and safety of the community and the fact that he committed a felony offense while on bond for 2 others, the court's respectfully denying the writ and the motion to reduce bond. And then now on this motion to withdraw, Mr. Stevens, you say you represented Mr. Henry.
Yes, sir. I previously have represented him in the past. My client's indicated he's innocent and that the co-defendant may possibly be the responsible party.
I got you.
Therefore, I believe I have a conflict of interest.
Are you court appointed?
I'm court appointed.
Okay, then what I'm going to do, Mr. Paul, if you'll have a seat, I'm going to figure out who's next on the list and we'll. Oh, she's right there. So they'll figure it out and we'll let you know before you leave today. What you got next?
Page 10 also, Dylan McIntyre.
Dylan McIntyre.
I believe he was on yesterday's docket. I think there was a positive test and I was held up in another court and we brought him back today.
Okay. All right, this is CR 21-0594-173, the state of Texas versus Dylan McIntyre. And this is set for status. Mr. Stevens was across the street yesterday, so we brought him back today. Mr. McIntyre tested positive for a controlled substance and the court found his bond insufficient and placed him in custody. Where are we at on status? Okay, and Mr. Stevens?
Your Honor, I will visit with my client. I thought we were just here for purposes of the drug test, but since it is in fact status, we held him over for. I'll visit with my client. I'm assuming that'll probably be a plea today.
Okay, yep, y'all get the paperwork done, I'll hear it.
Yes, sir. And then my other case will be a plea as well. We'll
And
circle back.
that's Bailey?
Yes, sir.
All right, thank you. Mr. Schmidt? David Wayne. All right, these are cause numbers. CR 19-0609-173 and CR 21-0923-173, both styled the state of Texas versus David Wayne. And let's see, the 923 case is set for arraignment. So Mr. Schmidt.
Judge, for the record, previously we were in court. I'd filed a motion to reinstate Mr. Wayne's bond pertaining to this issue here. The court granted that motion based on the fact that Mr. Wayne proven to the court that he was in the hospital via COVID test. So I'm a little bit surprised by this new indictment based on that.
Not me. Have nothing to do with the grand jury, just some paneling, and then they go on their own.
And so we understand, we would waive arraignment and if we would be able to resolve that with the DA's office pretty quickly.
All right, Mr. Wayne, the court, I guess, enters plea of not guilty on your behalf.
Yes, sir.
And you're going to receive 2 new court dates in writing. That is December the 8th at 9 a.m. for discovery status, and then again on January the 12th of 2022 at 9 a.m. for pretrial. And then the other case, which is set for status, I'm just going to reset it for status on December 8th at 9 a.m. That way we get all your cases, and then maybe y'all can work it out.
Will you be excused?
Yes, sir. Thank you. To see you. Yes, sir. Yeah, I got you.
Page 7, second one. Very appreciate it.
Ms. Pritchett.
Negative in the past, Your Honor. However, a negative UA today would go a long way towards me agreeing to the resolution that they're asking for.
All right, cause number CR 21-0084-173, the state of Texas versus Mandy Pritchett, set for pretrial. Any pretrial from the state?
Mr. Standard motion for discovery, Judge.
And on behalf of Ms. Pritchett.
Judge, we asked to put it on the status docket.
Okay, all right, well then the court deems pretrial is held. Ms. Pritchett, your next court date is November 10th at 1:30 for status. And that is generally your last day to resolve your case before it ends up on a trial docket. However, I'm going to order you to take a drug test today. You'll go take the test. I know you tested negative before. I hope you test negative today. When you get done, come back in the courtroom. We'll go over the results together. Thank you, ma'am.
Thank you, Judge. My big excuse.
Yes, sir. Good to see you. Mr. Head.
On page 4, Louis Corwin for status.
All right, it's cause number CR 19-0737-173, the state of Texas versus Louis Corwin, and that is set for status. Where are we at?
Your Honor, we had an agreement. Mr. Corwin has already waived the jury.
Okay.
He was supposed to have his restitution paid today, and the case is going to be disposed of. He's got the money in the bank. He's bought some records showing that the money's actually on a hold until the 19th due to how it was deposited. If we can reset it to the first part of November, we hopefully can just call Kevin and cancel that date. and have it
November
taken
10th?
care of.
November 10th, 1:30. So Mr. Corwin, if it's not resolved and dismissed by then, I'll see you back here on November 10th at 1:30.
Yes, Your Honor.
All right.
Thank you, Your Honor.
As soon as you have your reset notice, you're free to go.
Thank you, sir.
D'Angelo Russell on page 4.
D'Angelo Russell. This is cause number CR 21-0178-173, the state of Texas versus D'Angelo Russell. That is set for status. Where are we at?
Judge, if the court recalls, Mr. Russell was he was the victim in a couple cases that were pending before this court. Previously, Mr. Head and I had asked that we, kick the can down the road until those cases were resolved. Those cases since have been resolved. However, since they were resolved, Mr. Head and I haven't had a chance to discuss this case.
Who was the defendant that in this court?
Mr.
Yeah, they were out of this court.
Oh, Mr. Rockmore from this morning? Okay. All right, let's reset it to November 10th. And you're all right with that, Mr. Russell? You're the one being held to bail.
Yes, sir.
All right, well then I'm going to reset this case. Did I call it? Okay, I'm going to reset it to November 10th at 1:30.
And Your Honor, on page 5, 2 cases on Nicole Turner.
Nicole Turner. I got 3.
And Your That's correct, Your Honor. There are actually three now.
So we're gonna do three, please.
I think we're just doing the jury waivers today.
That's correct, Your Honor. We're gonna complete the jury waivers and set it for a plea, hopefully on the 10th.
Okay. All right, these are cause number CR 21-0495, 0496, and CR 21-0980-173, all styled the state of Texas versus Nicole Turner, and all set for pleas today. However, to my understanding, a jury waiver is going to be presented to the court. Is that correct?
One of them, we just filed an information stream on.
That's
The court was aware of that.
No, I got
correct,
that-
Your Honor.
That one.
And if we don't already have the jury waiver
Oh, I'm sorry. I thought you
done,
were-
I guess we may need to step back and get that
Okay,
done.
yeah, if y'all want to step back, and then I'll just have to admonish Mr. Turner, and then we can reset it.
And Your Honor, I'll take care of a few things then, and I'll
Okay.
approach it.
Mr. Stevens.
Judge Pike, page 9, Your Honor, Shaw.
Willie Upshaw. These are cause numbers CR 21-0026 and 0469-173. Both styled the state of Texas versus Willie Upshaw, and both set for status.
Yes, Your Honor. We have received an offer from the state. We've
It's
made,
at status. I'm sure you have.
yeah, well, I mean, we've been going back and forth on some offers. And we made a new offer just a while ago to try to resolve the issue. I don't think that Mr. Cox has had time to mull it over enough. And so we're going to ask.
Well, it's
I
at
don't
status.
think-
I hate to kick it down the road. If
Well,
it
see, I
does.
thought if we could get a short status, we might could resolve this thing instead of letting you go to the trial docket.
I can have 5 seconds, Mr. Stevens.
Set my timer. No, go ahead.
Your Honor, we're going to ask the case to go to the trial docket.
All right. And what was the offer then?
It was 3 years TDC,
3? And how much time does he have in?
1 year.
There, you got a year in. It's 3 TDC offer.
Yes, sir.
Look at him back. And so I've got the wrong, can I?
I'm sorry.
Still have Mr. Paul's here.
It's up to you.
Do I need to do paperwork?
Yes, sir. I think so. Judge.
All right, I'll recall it.
Thank you, sir. We'll wait just a minute, Judge. Can you recall us in a few?
Yeah, I think y'all need to talk. And for the record, he's facing 2 third-degree felonies, and so if he's convicted beyond a reasonable doubt by a jury or a court, then he's facing not less than 2 nor more than 10 and a fine of up to $10,000. Now, one is a bail jumping, the other is a PCS, right?
Yes, sir.
Can they be stacked?
Yes, sir.
Okay, so they could be stacked, and that's up to the court.
Okay, Judge. Thank you, Judge.
And he is in the top 5, so he'd go to jury pretty quick.
Okay, Judge.
Thank
When
you,
would
sir.
the next jury send?
November 15th.
Okay.
Mr. Stevens.
Jesse Bailey.
Jesse Bailey.
We've reached a plea agreement. However, we need to get a victim impact statement prepared. And so we're going to waive jury and come back next Wednesday for a plea.
27th.
Or 2 weeks, I apologize.
Just one case.
Correct.
All right, this is cause number CR 20-0711-173, state of Texas versus Jesse Bailey. Now, Mr. Bailey was set for status today. However, a jury waiver has been presented to the court And Mr. Stevens, you mind if I ask your client some questions regarding this waiver?
No, sir.
All right, Mr. Bailey, if you could raise your right hand the best you can. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God? You can lower your hand. Mr. Bailey, I've been presented this waiver of jury. Do you recognize this document? All right, and did you read and go over that with Mr. Stevens?
Yes.
Well, I'm sure he explained to you that both the United States and Texas constitutions guarantee you a right to trial by jury in this case. Do you understand that? And nobody can take that right away from you. Not Mr. Stevens, not me, not the state. If you want a jury trial, you can have a jury trial. Most people don't know, even on a Class C traffic ticket, you can request a trial by jury. Do you understand that? And do you want a jury trial? Do you want to waive your right to a jury trial? And you understand that I don't know what the deal is that y'all have with the state. However, if that falls through, I may not have to let you out of this jury waiver. You would still have a right to a trial, but that trial would be in front of a court, not a jury. You understand that? And you still want to do that? All right. And Mr. Stevens, do you believe your client has waived his right to trial by jury knowingly, intelligently, and voluntarily?
I do, Your Honor.
All right. Well, then the court finds that he has, and if we could sign it so that the state has consented. And further finds that the state has consented, and I have signed it this the 14th day of October, and we will reset this for a plea on November 27th at 9 a.m.
I'm sorry, I thought it was October the 27th.
October, sorry, October 22nd. Thank you. 27th.
And I think
Can I
that,
get that any more wrong? October
and I-
27th at 9 a.m.
and I think our announcement says September 27th, so we need to change it on our paperwork.
I've been trying to push us in November all month.
So everybody's off. So October.
I'll see you when I see you.
27th.
They'll bring you over. I'll be here.
Yes, sir. Thank you, Judge.
We told her. Spreading your COVID around. Miss Moore, Miss Apple, come on up. All right, this is cause number CR 21-0241-173, the state of Texas versus Wendy Applin. And this is set for status today. Where are we at?
Your Honor, Ms. Applin and I are asking for the case to be continued. She is in custody in large part because she's serving a state jail sentence. She should be discharging that. She believes October the 31st.
Okay.
And so we're asking for her case to be reset until sometime later this year.
And I would assume the rest of that time is going to be served here in the county jail.
I think it's probably a little late for her to get
Yeah,
transported. to-
you won't catch a chain. It's too short time. All right, well then, is the state all right with that?
Yes, Your Honor.
All right, well then, Ms. Applin, I am going to reset your status to, I said later, how about November 10th?
That'd be fine.
November 10th, 1:30. So if you discharge from that state jail sentence and you get out of jail between now and November 10th, I need to see you back here at 1:30. All right, see you then. Thank you, ma'am. Mr. Head.
Deanna Harris on page 5. Really, Harris. Please, that's listed.
Kimberly Harris. All right, it's cause number CR 21-0087-173, the state of Texas versus Kimberly Harris, and that is set for status.
Your Honor, we've not been able to reach an agreement. However, there's been a new arrest related to a game room. So I don't know if the court wants to go ahead and move this on to a trial docket or reset it to let us see if we can resolve that.
Can I see the docket sheet? Here's what I'm gonna do. I'm gonna order you to take a drug test today, Miss Harris. You know the drill. Go take the test. When you get done, come back in the courtroom. We'll go over the results together. In the meanwhile, we'll wait and see what the results are and figure out when and if we want to reset it.
Just step right over here to the side and I'll take care of it. Then, Your Honor, Mr. Turner, we have those jury waivers ready.
Mr. Turner, come on up. All right, these are cause numbers CR 21-0980, 0495, and 0496-173, all styled State of Texas versus Nicole Turner, and all set for pleas today. However, a waiver of jury in each of these cases has been presented to the court, and also a waiver of rights to indictment by a grand jury in the 980 case. And Mr. Head, you mind if I place your client under oath so I can ask him some questions about the waivers?
No, Your Honor.
All right, Mr. Turner, if you can raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. You can lower your hand. First of all, I'm going to talk about this 980 case. Mr. Turner, in this case, the court has been presented with a defendant's waiver of rights to indictment by a grand jury. And actually, you have not been charged by a grand jury or indicted by a grand jury. In this case, you've merely been charged by what we call information, which is just a document stating that the state believes that you've committed some offense, and it's signed by either the district attorney or the assistant district attorney. Do you understand that? And in Texas, you have a right not to answer to a felony case until or unless you've been indicted by a grand jury. Do you understand that? And can you tell me what a grand jury is? I can't hear you. You're close. It's basically a body of 12 people that are citizens of the county that meet in secret, and they look over the evidence and decide whether there's enough evidence that to convince them that there's probable cause that you've committed this offense. If 9 or more of those people believe that there is probable cause, well, then they can return an indictment. However, if less than 9 believe there's probable cause, then a letter would go over to the jail, if that's where you were, saying, hey, release him on this charge. He's been no bill. You understand this? In this particular case, again, you have not been indicted by a grand jury. Do you just want to wait on this new case and see if a grand jury will indict you? Or do you want to continue on with these waivers of juries? All right, well, I'm going to show you those waivers of jury. One of them is on that 980 case for which you have not been indicted. The others are on this 495 and 496 case for which you have been indicted. And Mr. Turner, I know that Mr. Head explained not only the grand jury system to you, but also the way the jury works is that you have a right under both a constitutional right under both the United States and Texas constitutions not or to have a trial by jury in this case. Do you understand that? And nobody can take that right or that right away from you, not Mr. Head, not me, and not the state. Do you understand this? Well, do you want to waive a jury?
Yes, sir.
Now, do you understand that whatever this deal you have worked out with the state is, that falls through and you don't work these cases out, I may not have to let you out of these waivers, just depending on the facts and circumstances. Do you understand that? In other words, if something happens and y'all's deal falls through, you may be stuck with these. Do you understand that? And then you'd only have a right to trial by the court instead of a jury. You understand that? Do you still want to waive this jury, the jury in each of these? All right, and Mr. Head, do you believe that he's made these waivers of the rights to grand jury as well as the pettit juries knowingly, intelligently, and voluntarily.
I do, Your Honor.
And the court finds that he has, further finds that the state has consented to the waivers of jury and the court's approving them and the waiver of rights to indictment on the 14th day of October. Mr. Turner, I just have to go over all that to protect all of us here. And when are we setting this? Same day we did the other one? 9 or 1:30? November 10th, 1:30. All three. So we'll see you back, Mr. Turner, on November 10th at 1:30 for a plea. All right. As soon as you receive your reset notice, you're free to go.
Your Honor, I had on page 3, Bradley Baker, he has 2 cases set for status and then also a writ that's pending. But we're not gonna have a hearing on that today, Your Honor.
Okay. All right. These are cause numbers CR 21-0274 and 0275-173, both styled the state of Texas versus Bradley Baker. And then CV 21-0489-173 ex parte Bradley Wayne Baker. And let's see, it's my understanding that Mr. Head is that you're going to pass the writ for today.
Yes, sir, Your Honor. We have still been trying to discuss some sort of resolution that might wrap up everything. If we could get something middle, latter part of next month, maybe that would give us time to continue to work through that and hopefully wrap up everything rather than leave some things
So we'll
hanging,
reset those statuses to that date.
if we could, Your Honor.
November 10th at 1:30. You'll be here for that plea anyway. Mr. Baker, you're the one in jail. You all right with that?
Yes, sir.
All right, then we will see you November 10th at 1:30.
I have 1 or 2 others we're still working on.
Yes,
Your
sir.
Honor. Thank you.
Mr. Harrington.
Sir. Mitchell Roberts.
Mitchell Roberts. This is cause number CR 21-0446-173, the state of Texas versus Mitchell Roberts, set for status.
Your Honor, I spoke to this state about this. I would request maybe one more statement of status conference, if they would get resolved in the meantime.
All right, well, Mr. Roberts, I'm going to reset status to November 10th at 1:30. However, I'm going to order you to take a drug test today. You'll go with probation, take the test. When you get done, come back in the courtroom. We'll go over the results together. Same one, November 10th, 1:30.
Clearly in the same page. That's the number of cases. I believe.
All right, Mr. Whaley, come on up, sir. These are cause numbers CR 21-0337, 38, 39, and 40-173. And all of these are styled the state of Texas versus Raymond Whaley, and all set for status.
At this time, the state has extended plea offer. It's been rejected by Mr. Whaley. I guess request for consent of the jury document.
All right, and what is the offer?
Right now, I believe it's 10, 10, 2, and 2.
That's correct.
Does he have any alleged priors?
No. No.
Okay. All right, well, Mr. Whaley, then the court notes that you've rejected the offers, places your case on the trial docket, and when is his, where is he at? Number 2, is that ag assault with a deadly weapons at a first? Second, 2 to 20. And when is that trial?
That trial is gonna be November 15th.
We want to set an announcement on it. And the 15th is trial day, right? Okay. All right, then, Mr. Whaley, then I'm resetting you for November the 9th at 9 a.m. for announcement. And then your number 2, if the number 1 case goes away, then we'll pick a jury on your case at 8:30 a.m. on November 15th. And we're trying all these together.
To be determined.
All right, Mr. Whaley, we'll see you on the 9th.
Yes, sir.
Thank you. Mr. Scott?
Gregory Ward for a plea.
Oh, getting ready to say, I was getting ready to look at. No, I ain't say we haven't done any, we haven't worked any out today, but we have. But I guess jury waivers. Mr. Ward? Come on up, sir. This is cause number CR 21-0506-173, the state of Texas versus Gregory Ward. And that was set for pretrial today. However, a plea has been presented to the court. Is the state ready?
We are on.
And on behalf of Mr. Ward,
We're ready, Your Honor.
all right, sir, is your name Gregory Allen Ward Jr.?
Yes, sir, it is.
And are you the same person that was originally indicted by a Henderson County grand jury for this 3rd-degree felony offense of evading arrest or detention?
Yes, sir, I was.
If I can get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
You can lower your hand. Mr. Ward, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, I am.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir, I do.
And Mr. Ward, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today?
Yes, sir.
And Mr. Scott, do you believe your client is competent?
I do, Your Honor.
And the court finds that he is. Mr. Ward, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? But do you understand the charge?
Yes, sir, I do.
Well, as indicted, that charge is a 3rd-degree felony, which carries a punishment range of not less than 2 years nor more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that range?
Yes, sir, I understand.
However, it's my understanding that in exchange for your guilty plea, the state's willing to recommend that the court convict you of a lesser included offense of evading arrest, which is a Class A misdemeanor. A Class A misdemeanor carries a punishment range of not more than 1 year in the county jail and a fine of up to $4,000. Do you understand that range?
Yes, sir.
In the plea bargain?
Your Honor, it's 1 year in the Henderson County Jail, so wait 2 years. 3 days credit plus court costs.
Is that your understanding of the plea bargain, Mr. Ward?
Yes, sir.
And is that your understanding, Mr. Scott?
Yes, Your Honor.
And Mr. Ward, a few minutes ago, you told me you could read and write the English language. I want to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Scott?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with
Yes,
Mr.
sir.
Scott? Did you sign the second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with him?
No, sir, I don't.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
You want to do this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that lesser included offense of that which is charged in the indictment, the Class A misdemeanor evading arrest? Are you guilty or not guilty?
I'm guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I'll hear the evidence.
Judge, I have states 1 in offense report and states 2 is my more compliance.
No objection, Your Honor.
Admitted.
State rests.
In arrest, Your Honor.
All right, Mr. Ward, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that Class A misdemeanor offense of evading arrest. The court will follow the plea bargain, considers the misdemeanor reckless driving and sentences you to 1 year in the county jail. However, the court will probate that, places you on community supervision for 2 years. You do have 3 days credit as to any sentence you may eventually have to serve, and orders you to pay your court costs and abide by all the regular and special terms and conditions of community supervision. And Mr. Ward, have you ever been on probation? Did you successfully complete it? Or what happened to you? What happened to you? Did you go to jail?
Yes, sir.
County jail, prison, or state jail?
I ended up going to Bradshaw State Jail.
You went to state jail, so you know what can happen to you, right?
Yes, sir.
You know what can happen to you if you violate this probation?
Yes, sir. I can do a year.
That's right. Here's what can happen. If you violate even one term or condition of community supervision, a motion could be filed, a warrant would be issued for your arrest, you'd be placed in jail without bond, brought back before the court, and if at a hearing, the court found it were true that you violated even one term or condition, the court could revoke your probation and sentence you up to a year in county jail, you understand?
Yes, sir.
So would you agree with me? It's extremely important you abide by these.
Yes, sir.
I hope you do, sir. Good luck to you. You need to see probation.
That's yours. I've got Rodney Bracken, John.
Rodney Brackens.
I was gonna bring up, that's he completed Senate court, he completed a drug program while he was on bond, so I meant to bring that up while you're considering the plea.
All right, it's cause number CR 21-0454-173, the state of Texas versus Rodney Brackens. And this is set for status.
These two cases, there was an offer. but
That was
then
another
there's
one.
A new unindicted case that's going to be presented to the grand jury this next session.
Okay.
Also, he's got a case of rehab out in Navarro County that he hasn't been arraigned on yet. So I spoke with the assistant DA over there and trying to craft some kind of
Okay.
offer.
When did he get out of Senate for?
This is my other client.
Oh, I thought you were talking about him.
Yeah,
Okay.
I meant to tell you that during the plea. I was
Oh.
gonna bring that up for you to consider, but no, he's.
Okay, I got you. Can I see the docket sheet on this one? And it's, so what I'll do is I'll reset it since he's got those other cases. All right, he was negative the last time. When were those other cases alleged to have been committed?
Both of them in May.
Okay. All right, Mr. Brackens, you tested negative last time, so I'm not going to test you today, but I'm liable to test you when you come back in.
Yes, sir.
And so I'm going to reset status to November 10th at 1:30, and y'all can figure out, see if you can't get a package deal.
Sir.
All right, remember your conditions of bond, Mr. Brackens, and I'll see you in November.
Yes, sir.
All right, thank you.
Your Honor, I don't know if there's a warrant out for him or not. So
I don't, do you have one? A warrant? For Mr. Brack? I don't show one.
he might, I think he has a retained attorney out in Navarro County.
Okay. You can't check NCIC or TCIC? DA's office does. Anything else?
Oh, no, Your Honor.
Oh, all right.
May I have excused?
Yes, sir. We'll
Thank
see you in
Judge.
November, Mr. Brackens. Mr. Green.
Aaron Anderson, Judge, for plea.
Mr. Anderson, come on up. Anderson. You getting irritated over there, kid? All right, it's cause number CR 21-0904-173, the state of Texas versus Aaron Anderson. Case is set for arraignment today, so let's go ahead and arraign him first. Mr.
Judge, we
Green.
arraigned him this morning.
Oh, we did?
Yes, sir. And then
It still
moved
says arraignment.
and
That's
then moved
right.
into this afternoon for the plea.
Seen too many people today, Mr. Anderson. All right, please been presented to the court as a state ready. And on behalf of Mr. Anderson,
We're ready, Judge.
sir, is your name Aaron Cecil Anderson?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for this felony offense of possession of a controlled substance?
Yes, sir.
And get you to raise your right hand the best you can, please, sir. You solemnly swear or affirm the testimony you're about to give now on trial to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
You can lower your hand. Mr. Anderson, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it will have certain negative immigration consequences. Do you understand that?
I do.
And Mr. Anderson, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here?
Yes, sir.
And Mr. Green, do you believe your client is competent?
I do, Your Honor.
And the court finds that he is. Mr. Anderson, I know that you've already been arraigned this morning on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir.
But do you understand the charge?
I do.
Well, as indicted, that charge is a third-degree felony, which carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that range?
Yes, sir.
However, it's my understanding that in exchange for your guilty plea, the state is willing to recommend that the court reduce this to a lesser included offense of possession of a controlled substance under 1 gram, which would be a state jail felony. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine of up to $10,000. Do you understand that range?
Yes, sir.
And further, the state is willing to recommend in exchange for your guilty plea that the court convict you as a state jail felon, yet punish you as a Class A misdemeanor under 1244A of our penal code. And the punishment range for a Class A misdemeanor, it's not more than 1 year in the county jail and a fine of up to $4,000. Do you understand that range?
Yes, sir.
In the plea bargain?
Your Honor, 6 months confinement in state jail felony facility, credit for 125 days served. Plus attorney's fees,
I got it.
court costs and lab restitution. We're also asking the court to consider and dismiss 2021-0194 CCL and an unfiled, unindicted JD main motor vehicle from June 11th, 2020.
You said in a state jail felony facility, it's 1244A.
Yes, Judge, I'm sorry.
Okay, so
In the Henderson County Jail.
all right. Is that your understanding, Mr. Anderson?
Yes, sir.
And is that your understanding, Mr. Green?
It is, Your Honor.
Well, Mr. Anderson, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front
I did.
and the back with Mr. Green?
Yes, sir.
And did you sign the front and the back?
I did.
Do you have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both of those pages of that document with Mr. Green?
Yes, sir.
And did you sign the second page?
Yes.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with him?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
You want to do this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that state jail felony offense of possession of a controlled substance punished under 1244A of our penal code? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I'll hear the evidence.
Judge, I have states 1 copy of the offense report. States 2 is my warrant compliant. States 3 is a lab report.
No objections.
Admitted.
State rests.
Rest of closure, Your Honor.
All right, Mr. Anderson, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included offense, the state jail felony of possession of a controlled substance. The court will follow the plea bargain considers those two cases on the agreed plea recommendation and sentences you under 1244A of our penal code to 6 months in the Henderson County Jail with credit for 125 days and orders you to pay your attorney's fees, court costs, and restitution. A couple things before you go, Mr. Anderson. Did you get an opportunity to review the judgment of conviction in your case?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
All right, sir. And now that you've been finally convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult an attorney. You're now remanded back to the custody of the sheriff to serve out the remainder of your sentence. Good luck to you, sir.
Thank you, sir.
You need to see the bailiff before you have a seat. Yes, sir.
I'm still working on my other stuff.
Ms. Fallhaber.
William,
William Hesseltine. Not too big of a lunch. All right, it's cause number CR 21-0421-173, the state of Texas versus William Hesseltine, set for pretrial. Any pretrial from the state?
Yes, did you sign our standard order of discovery on it?
no objection.
Granted, and on behalf of Mr. Hesseltine.
Your Honor, we had carried over as well discovery status because at the last hearing, there was still lots of outstanding discovery. And so I'm not prepared to make an announcement regarding pretrial at this point. Last week, I received several hours of jail phone calls that I haven't even been able to get all the way through yet.
Hold on now. Are they his jail phone calls?
Yes,
Then he is in a, we do this every time we go to trial and jail phone calls come in. He knows what's on those calls if they're his calls. And he can inform you if there's something on there. And so I'm always reluctant to continue things because of jail calls made by the defendant.
Nick. who's with me now.
Yes.
Furthermore, yesterday I received a disc with several recordings on it that I've also not had time to review. Those were actually recorded phone calls that I made reference to at the last hearing that were mentioned in the CPS records that I've received before that. And also yesterday I received 54 pages of printed documents and 123 pages of counseling.
The other recorded phone calls, what were
Your
those?
Honor, there's CPS records that we provided to Ms. Fallhaber. They referenced 2010 and 2011 intake calls that she asked us to look into. We did look into that. We provided her with the retention records of CPS, so those don't exist. There were a couple of other interviews that were on the CPS records that she had not received, and we have provided those to her along with counseling records. And I didn't catch what the other thing is that you said that you just got.
It was the counseling records, the retention records, and recordings that I got yesterday.
So we provided them all to her.
But the recordings you got are jail recordings.
No, there's other recordings of interviews.
Okay, I got you. All right, well then what I'm going to do is I'm going to reset pretrial to November 10th, not based upon the defendant's phone calls, but based upon the other information you received.
Yes, sir.
And so we'll just take a look at it on November 10th. If you need more time, so let Kevin know. I know it's a lot of documents. 1:30.
I don't know why that date is sticking out.
Ms. Pritchett, you passed your test. You're free to go. We'll see you in November.
May you be excused?
Yes, ma'am.
Thank you.
They said they would have something worked out next time, I think. Because he's already left. Yes, ma'am.
Joe Caroline.
Joe Paroline. I don't have a punishment on here.
It's the first part of an open plea, Your Honor.
Oh, it's an open plea. Okay. So give me just a minute. All right, this is cause number CR 20-0575-173, the state of Texas versus Joe Dan Paroline Jr. And this is set for a plea today. Is the state ready?
Ready, Your Honor.
And on behalf of Mr. Paroline,
Ready, Your Honor.
sir, is your name Joe Dan Paroline Jr.? And are you the same person that was indicted by a Henderson County grand jury for this third-degree felony offense of possession of a controlled substance? I get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand. Mr. Paroline, can you read and write the English language? Are you a U.S. citizen? It turns out you're not, and you enter into this plea bargain with the state, can have certain negative immigration consequences. Do you understand that? And Mr. Paroline, have you ever been treated for any mental health or emotional issues?
No.
Do you understand what's going on in here? Ms. Fallhaber, do you believe your client is competent?
I do, Your Honor.
And the court finds that he is. Mr. Paroline, I know that you've already been arraigned on this case. However, would you like the state to read the indictment out loud here in the courtroom? Would you?
Do you need them to read the indictment? Do you need them to read the indictment?
Okay, but do you understand what you're charged with?
Your Honor, can we have a moment, please?
Sure. Give the court reporter a break anyway. We've been going solid.
Yes.
Does we have to call timeout on this? I'm sorry.
That's okay. Each side gets 3 per half.
What's that?
Each side gets 3 timeouts per half.
All right, I'm gonna have to go rediscuss with my client.
And I think I've got Mr. Schmidt. I can take him. And we've also got Mr. Mills. I just saw you there, Mr. Mills. All right, Mr. Schmidt, can you hear me?
Yes, I can, Judge.
All right, and who do you have?
Randall West.
Randall West. All right, this is cause number CR 21-0200-173, the state of Texas versus Randall West, set for status.
Judge, I've been out the last couple of days, obviously, and so we have an offer on the table that we were discussing until everybody in my house started getting sick. And so if we could just reset this one more status, I think we'll get it worked out. It's a probation offer, so I think we're close.
Mr. West, you all right with that?
Yes, Your Honor.
All right, well, then I'm going to reset your case to November 10th at 1:30.
Yes, sir.
Thank you, Judge.
You're going to get a reset notice. Can you run a copy of it over to, he's going to get 2, run a copy over to Mr. Schmidt's office. You
Yes,
know where
sir.
that's
Sure.
at? That way they have it.
Yes,
We'll
sir.
see you in November.
Thank you, Your Honor.
Thanks, Randy.
Thank you.
Might be excused, Judge.
Yes, sir. Thank you. Mr. Mills,
Yes, sir. I have Keith Rucker, Your Honor.
Keith Rucker.
Yes, sir.
Oh, you're on Zoom. That's right.
Yes, sir.
Hold on a second. All right, let me call your case. Now, why is Mr. Rucker on Zoom?
Oh, hi. Sorry.
Something wrong with his leg? What's wrong with your leg, Mr. Rucker?
I got CBD, coronary vein disease. My leg is 3 times the size it's normally supposed to be, and it's hard to walk.
Let's see the docket sheet. Back in August, it looks like he was quarantined, and today your leg's all swole up. And the last time you were drug tested, he tested positive for methamphetamine.
No, I have a negative one too.
Mr. Mills, I got people rolling here in wheelchairs. I mean,
Judge, I don't know. He called me this morning and telling me about his leg being all messed up and that he couldn't stand for very, very long.
okay, well, I don't need him to stand for long, so let's go ahead and hold the hearing, and then I'll make some other orders. All right, these are cause numbers CR 20-0656 and 0657-173, both styled the state of Texas versus Keith Rucker, and both set for status.
Yes, Your Honor, he has 3 other cases that are unindicted. I do have a new offer that I have not relayed to Mr. Mills yet to wrap them all up based on information.
And do we have, what are the offense dates of these other alleged offenses?
One was a Mandel. We got a lab back.
But how long ago?
It's been past 6 months.
Okay. And what are the other 2?
One is another drug and one's a failed to register as sex offender.
All right. Well, Mr. Rucker, you and your attorney are both appearing via Zoom. I'm going to reset this status to November 10th at 1:30. And I'm ordering you to report at 9 a.m. tomorrow morning to probation to take a drug test.
Yes, sir.
And let's see, when is our very next court? Is Mr. Mills here already? When's the next time Mr. Mills is here? And then I'm setting you for November 3rd at 1:30, and we're going to go over the results of your drug test.
Yes,
So
sir.
either you're either dodging the court or you are just a victim of a series of unfortunate events.
Yes, sir.
Thank you, Judge. May I have an excuse?
Yes, sir. Thank you.
Thank you,
Mr.
sir.
Rucker, they'll see you at 9 o'clock tomorrow morning, and the probation department will call me at 9:10 and let me know whether you were there or not.
Yes, sir. Thank you,
All
sir.
right, you can log off. Is that all we have for Zoom? Is that everybody? Okay. Okay, that's all right. I'll just wait. Ms. Fallhaber. Mr. Paroline, come on back up. All right, we're back on the record in CR 20-0575-173, the state of Texas versus Joe Paroline. And I was in I think we were at the point, I don't even remember where I was. Been a long week.
Because we need to go over the terms of the agreement again.
But where did I end up? I went over the range of punishment. Is that correct?
Yes, and that's where the issue arises, Judge.
Okay. Well, let me back up, Mr. Paroline. I've already identified that you are the person indicted. I've already admonished you on immigration status, inquired as to whether you can read or write the English language, and your competency, and I found you competent. And I believe you waived the reading of the indictment. Is that correct? All right. Well, Mr. Paroline, the punishment range for this offense is, as originally indicted, that possession of a controlled substance would normally be carry a punishment range of not less than 180 days nor more than 2 years in
Your
a,
Honor, that's the other case.
is it
Pleading to the 1 to 4.
the third? Okay, I thought it was a state jail enhanced by 2 prior felonies. So this is a third enhanced, okay, ooh, okay. All right, so back up. On this case, 0575, as originally charged, the underlying offense is a third-degree felony, which carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that punishment range? However, there are 2 enhancement paragraphs alleged in this indictment. If you were to go to trial and be found guilty beyond a reasonable doubt, at punishment, if the state proved these 2 enhancement paragraphs true, then the punishment range would be that, or be not less than 25 years nor more than 99 years or life in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that punishment range?
Yes.
Are y'all abandoning 1 or 2?
We're abandoning 1.
All right. However,
They're abandoning.
it's my understanding that the state is going to abandon 1 of those enhancement paragraphs, which would mean if that other enhancement paragraph were true, the punishment range would be that of a second-degree felony of not less than 2 years nor more than 20 years in the Texas Department of Criminal Justice and a fine of up to $10,000. So do you understand all the different punishments in the plea bargain?
Your Honor, we've agreed to abandon 1 enhancement paragraph in exchange for his plea of guilty, so he'll be going over to the court on a 2 to 20 punishment range. We're also going to ask the court to consider CR 19-864, 173, and 2020-0489 CCL2.
What is that? 489?
It is a state jail PCS.
No, the misdemeanor.
POM.
Possession of marijuana. Okay. All right. Is that your understanding of the plea bargain, Mr. Paroline? In other words, the only deal that you have with the state is that they are not going to try to prove up at a punishment hearing 1 of these enhancement paragraphs. So the punishment range would be not less than 2 nor more than 20. Understand that? All right. And is that your understanding, Ms. Fallhaber?
It is.
Well, Mr. Paroline, a few minutes ago, you told me you could read and write the English language. I'm going to go over a couple documents with you. Well, just one is the agreed plea recommendation. Did you read and go over both the front and the back with Ms. Fallhaber? Did you sign the front and the back? Do you have any questions about it? Do you have any questions about any of these documents that you signed? Well, if you read and went over these with Ms. Fallhaber, I know she explained to you that you have many constitutional rights, including the right to trial by jury. You understand that? And I don't have the court's admonishments. I'm about to go over them. I mean, you understand that at a jury trial, you could not be convicted unless 12 jurors unanimously found you guilty beyond a reasonable doubt. Do you understand that? And if during that trial, you would have a right to help your attorney cross-examine the witnesses against you. And you'd have a right to call your own witnesses if you want to. But if you didn't call any witnesses and you didn't testify, nobody could hold that against you. Do you understand that? In fact, I would even instruct the jury that they couldn't consider that for any purpose if you didn't call any witnesses or testify. You understand that? And finally, if you were convicted beyond a reasonable doubt, you would have a right to appeal any of the jury's verdict and any rulings the court would have been required to make during the trial. Do you understand that? All right. Now, understanding all that, do you want a jury trial? All right. Do you want to do this plea bargain, knowing that the only deal you're getting is 1 enhancement paragraph being amended? All right. Then I'll ask you, sir, then how do you plead to that felony offense of possession of a controlled substance as alleged in the indictment? Guilty or not guilty? And are you pleading guilty because you are and for no other reason? And which enhancement paragraph are y'all abandoning?
We'll abandon the first one, Judge.
All right. And Mr. Paroline, is it true or not true that in August of 2012 in Van Zandt County, you were finally convicted of the felony offense of burglary of a habitation? Is that true or not true? True or not true? And are you pleading true because it is true and for no other reason?
Yes.
I'll hear the evidence as to guilt innocence.
Judge, I have State Exhibit 1, an offense report. Stage 2 is Michael Morgan compliance. Stage 3 is a lab report.
No objection.
Admitted.
State rests as to guilt innocence.
Rest for guilt innocence and we'll be requesting a PSI.
All right, Mr. Pearline, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that felony offense of possession of a controlled substance. Based upon your plea of true and the evidence, the court has enough evidence to find it true and does find that second enhancement paragraph true. The court is going to set this for sentencing on.
Would it be possible to have it in January, please?
I'm here when you tell me to, Kevin. January 10th, 9 a.m.
I'm so sorry. Actually, no. Well, I have a jury trial announcement in Rivera County that morning. The felony jury trial announcement, sorry.
Sunday, 1:30.
January 10th. That should work.
All right, January 10th, 22, I almost wrote 21 at 1:30. And I'm going to make the PSI due by November 29th. November 29th.
You can get a copy. January 10th.
All right, so the court will recess as to guilt, innocence, and we will have sentencing on January 10th at 1:30.
Thank you. May we be excused?
Yes, ma'am. And Mr. Pearline, that's a long time for sentencing. Remember, you do have conditions of bond. Okay, and if the state alleges you did anything between now and January, I'm sure I'll hear about it if they allege at your sentencing hearing. All righty, we'll see you then. Okay, we're gonna have to take a real quick break. Actually, we'll take a 15-minute break. We'll reconvene at 3 o'clock.
Hold on. Hold on. Well, you know the rest of it.
Okay, scared me.
better.
Yeah. She's on the road.
Enjoy life.
Oh, yeah. Hey, did you, did you bring your award with you today?
Children like that too. Okay, here's your number.
Not the newest thing. Single,
Well, yeah, I would have to. But I can't. I don't know. Too much family, that.
All rise.
Thank you. All right, continuing on with open announcements on the 1:30 docket, Mr. Head.
Corey Masick, who I do not believe has appeared, and we needed to just call the case.
All right, Corey Masick, Mazzyck. Is there a Corey Masick in the courtroom? I see no one. I hear no answer. All right, his name was called 3 times in the lobby. He's not present. The time is now 3 o'clock. He was set and notified in open court to be present today at 1:30. Court will entertain a motion. Granted capious issue, he'll be held with no bond.
Yeah, I think the other thing I had was waiting on a drug test.
Okay. Mr. Green.
Melvin Keel, Judge.
Melvin Keel.
Page 2.
All right, these are cause numbers CR 20-0503 and 0504-173, both styled the state of Texas versus Melvin Keel, and both set for status.
Judge, we've reset it a couple of times for status conference because we were waiting on some CPS records. Ms. Palmer advised me this afternoon that they received them today.
Okay.
I haven't received them, but once I do, I'll need some time to review those.
Does that to protect the ward judge for those CPS records?
We have no addiction.
All right, and then I'm signing them. Those are granted. I'm going to reset then. Mr. Keel, reset your status to November 10th at 1:30. Good. All right. See you then.
Joshua Parnell, Judge.
Joshua Parnell. Cause number CR 21-0526-173, the state of Texas versus Joshua Parnell, set for status.
Judge, Ms. Carpenter made an offer this afternoon that I've conveyed to Mr. Parnell. He would like to have some time to consider that offer, and would just ask that the status conference be reset.
What's the offer?
15 TC.
Does it, well, how long are you going to keep it open? Or indefinitely?
The next court set.
All right, I'm going to reset this to November 10th at 1:30, Mr. Parnell.
And Judge, just for the record, that Ms. Carpenter did offer 15, did indicate that she thought the state would be able to accept a 10-year agreement if so.
Okay.
That's why Mr. Parnell kind of got wide-eyed for a minute, so.
Okay, all right, and then we'll see you November 10th, Mr. Parnell.
Davion Wilson, Your Honor.
Davion Wilson.
Top of 3.
This is cause number CR 18-0185-173, the state of Texas versus Davion Wilson, set for status.
Judge, Mr. Cox and I have been working towards a resolution on this case. Since we were here last time, he made an offer, I made a counter offer. That's kind of where we are right now.
Just want me to put it on trial docket? I mean, is this our first status? Typically only give one status, but it's new COVID world. How many times?
Judge, honestly, I don't know.
We've been having status since July.
Initially, it was because of some discovery issues.
Right.
I can't tell you how many statuses we've had since those issues were resolved. So,
Well, you're right. So it's August. I think we got all that worked out. September, In September, status, working to resolve, reset today, status.
So
I'm gonna place it on a trial docket. What number is he? And what's the offer?
Offers 4 TDC on a lesser deadly conduct.
And what is he charged with? It's
Assault deadly weapon.
second degree, 2 to 20, and offers 4. Number 1, almost a year. And that's for jury, picking a jury win. All right. All right, well, then he will be number 1, 15th of November. Announcement on that is. I think you just told me a little while ago. Announcement, November 9th. Announcement, November 9th, 9 o'clock, and we'll pick a jury on November 15th at 8:30. And are you gonna hold that offer open to the 9th? No, so you'll have some time to think about it, Mr. Wilson. If not, then we'll pick a jury on the 15th at 8:30, sir. And that is a 3G or the old 3G, an aggravated offense. So if he were convicted beyond a reasonable doubt at sentencing, he would have to do at least half if the deadly weapon was found to be true. Okay. But your offer doesn't include a deadly weapon. It's just 4 straight. And he's got a year in.
yes, sir.
Okay. All right. Well, then we'll see you on the 9th. Sir. He's got it.
Well, he's only got 1. You must have kept the pink copy. Thomas Conklin, Judge.
You're gonna run it over to Schmidt's office? It's
What?
an inside joke.
Oh.
He was on Zoom, but he wanted all his clients to drop the reset off at his office.
Oh.
So Danny asked me if he couldn't just write it down while he had a pen. Now let me sign him and then we'll get started, Mr. Conklin. All right, this is cause number CR 21-0407-173, the state of Texas versus Thomas James Conklin Jr. And that is set for, let me see if I can find it. Set for status today, however, a plea has been presented to the court. Is the state ready?
We are, Your Honor.
And on behalf of Mr. Conklin,
We're ready, Your Honor.
all right, sir, is your name Thomas James Conklin Jr.?
Yes, sir.
And are you the same person that was originally indicted for this first-degree felony offense of manufacture, delivery of a controlled substance?
Yes, sir.
I need you to raise your right hand the best you can, please. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand. Mr. Conklin, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
Mr. Conklin, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today?
Yes, sir.
And Mr. Green, do you believe your client is competent?
I do, Your Honor.
And the court finds that he is. Mr. Conklin, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a first-degree felony, which carries a punishment range of not less than 5 years or more than 99 years of life from the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand the range?
Yes, sir.
In the plea bargain?
Your Honor, it's 5 years TDC, probate 3 years. $1,000 fine, attorney's fees, court costs, lab restitution, and he has 87 days credit towards a potential sentence.
5-year on a man, 5-year or 3-year probation on a man delivery?
It's a, I think it was
I was indicted for under.
no, it's 7 grams, I think, Judge.
Okay. All right, is that your own? It's a COVID world. In the past, I probably wouldn't have accepted. I know I wouldn't have. All right, is that your understanding of the plea bargain, Mr. Conklin?
Yes, sir.
All right, is that your understanding, Mr. Green?
It is, Your Honor.
All right, Mr. Conklin, a few minutes ago. Well, I'm sorry. Yes, you told me you could read and write the English language. It's been a long week. I'm gonna go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that with Mr. Green?
Yes, sir.
And did you sign it?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
Did you sign the second page there?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Green?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to do this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that first-degree felony offense of manufacture, delivery of a controlled substance? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I'll hear the evidence.
Judge, real quick before I offer the evidence, does the plea sheet indicate which paragraph we're proceeding on?
No.
Okay.
Paragraph A is Mandel and paragraph B is
Just the possession.
possession. Are y'all proceeding on the possession?
Yes, Judge. Paragraph B, the possession.
Okay.
We're going to abandon paragraph A, the manufacturer delivery.
Paragraph B. Okay. Where was it?
No, I need to give you the evidence.
Yes.
States 1, Judge, is an offense report. States 2 is Michael Morton compliance, and States 3 is a lab.
No objection.
Admitted.
State rests.
So suppose.
All right, Mr. Conklin. I'm going to go back. As far as Mr. Conklin, I didn't ask you which paragraph. As to that first-degree felony offense, it wouldn't be a first, it'd be one, no, it would be. As to that,
Paragraph
no,
B is
it'd be a
second.
second-degree felony offense. So let me back up. Yeah, because it's 4 to 200. All right, so Mr. Conklin, I'm going to back up a little bit. The punishment range on paragraph B is not less than 2 nor more than 20 years in the Texas Department of Criminal Justice and a fine of up to $10,000. You understand that range?
Yes, sir.
All right, then I'll ask you, sir, how do you plead to paragraph B of that indictment? Are you guilty or not guilty? And are you pleading guilty because you are guilty and for no other reason? All right. And then the court's granting the state's motion to abandon paragraph A. And the court having heard the evidence from the state and any evidence from.
We rest of those.
All right, Mr. Conklin, and based upon your guilty plea as to paragraph B and the evidence, the court has enough evidence to find you guilty and does find you guilty of paragraph B, that possession, not the Mandel. The court will follow the plea bargain, sentences you to 5 years in the Texas Department of Criminal Justice. The court is considering those 2 cases that are annotated on the agreed plea recommendation and sentencing you. However, the court will probate that, place you on community supervision for a period of 3 years. You do have 87 days credit as to any sentence you may eventually have to serve in order you to pay your fine, attorney's fees, court costs, and lab fee, and to abide by all the regular and special terms and conditions of community supervision. Mr. Conklin, have you ever been on probation before? All right, was this his first offense?
I believe so, Judge.
Okay.
Yes, sir.
Righty then I may have accepted it pre-COVID. All right, well, Mr. Conklin, there's lots of things you have to do and a few things you can't do on probation. You understand that?
Yes, sir.
And you know it can happen to you if you violate any term or condition of this probation.
Yes, sir.
What can happen?
I'll be right back on that.
Here's what can happen. A motion could be filed, a warrant would be issued for your arrest. You'd be placed in jail without bond. You'd be brought back before the court. And if at a hearing, the court found it were true that you violated even one term or condition, the court could revoke your probation and sentence you up to 5 years in TDC. Do you understand that?
Yes, sir.
So would you agree with me? It's extremely important you abide by these terms and conditions.
Yes, sir.
All right, sir, and now that you've been finally convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions, consult an attorney. You're now remanded back to the custody of the sheriff for release, and you need to see probation. First thing when you get out, and you need to see the bailiff before you have a seat.
Yes, sir.
Mr. Harrington. We have Roberts. I've got Miss Harris's. Did we already do have we already handled Miss Harris? We have not. Okay. All right. Let's see. Can I see the back of the sheet? All right, it's cause number CR 21-0446-173, the state of Texas versus Mitchell Roberts. Mr. Roberts was ordered to take a drug test today based upon the nature of his charge. Mr. Roberts was positive in June for methamphetamines, amphetamines, benzodiazepines, and opiates. He was negative in September. And however, today he is positive for methamphetamines and amphetamines. And so, Mr. Roberts, I'm finding your bond insufficient. What is his bond at right now? All right, so your bond, I'm doubling your bond. Your bond is now $20,000 surety bond with the same conditions, sir.
Thank you, Judge.
Did he have an offer?
Judge, it's 25 years to proceed.
Okay. All right, sir. I'm remanding you to custody of the sheriff. Says girlfriend could have potentially used around him. Potentially. Well, she's the one that's upset in the back of the room. Now a drug test her too. All right, Mr. Stevens. Mr. Upshaw, come on up, sir. Took the last Ricola? All right, this is cause number CR 21-0026-173, the state of Texas versus Willie Upshaw. And this was set for status today. A new offer was made at status and a plea has now been presented to the court. Is the state ready?
We are, Your Honor.
And on behalf of Mr. Upshaw,
Ready, Your Honor.
sir, is your name Willie Donnell Upshaw Jr.? And are you the same person that was originally indicted by Henderson County Grand Jury for this third-degree felony offense of possession of a controlled substance? And get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial to be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand. Mr. Upshaw, can you read and write the English language? Are you a U.S. citizen? If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? And Mr. Upshaw, have you ever been treated for any mental health or emotional issues? Do you understand what's going on in here today? And Mr. Stevens, do you believe your client is competent?
Yes, Your Honor.
And the court finds that he is. Mr. Upshaw, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? But do you understand the charge? Well, as indicted, that charge is a third-degree felony, which carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that range of punishment? In the plea bargain?
Your Honor, it's 2 years confinement, PVC, credit, 307 days served. Plus attorney's fees, court costs, and land restitution. We're also asking the court to consider and dismiss CR 21-0469-173 undecided aggravated assault with deadly weapon from May the 15th, 2021. Judge, regarding that aggravated assault, Ms. Carpenter wanted me to put on the record, she spoke with the victim in that cause, and the victim in that cause is requesting that we not prosecute.
Just basically she's requesting you do not prosecute. Correct. Okay. Is that your understanding of the plea bargain? Is that your understanding, Mr. Stevens?
Yes, it is, Your Honor.
Mr. Upshaw, a few minutes ago, you told me you could read and write the English language. I'm going to go over two documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that with Mr. Stevens? And did you sign the front and the back? Do you have any questions about it? Next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with him? And did you sign there on the second page? Do you have any questions about it? Do you have any questions about any of the documents that you read and went over with Mr. Stevens? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial? You want to do this plea bargain? And I'll ask you, sir, how do you plead to that third-degree felony offense as alleged in the indictment? Guilty or not guilty? And are you pleading guilty because you are and for no other reason? I hear the evidence.
Judge, I have states 1 an offense report, states 2 is my more in compliance, and states 3 is a lab.
No objections.
Admitted.
State rest.
Defense rest, Your Honor.
All right, Mr. Upshaw, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense. The court will follow the plea bargain, considers those two cases in the plea recommendation and sentences you to 2 years in the Texas Department of Criminal Justice with credit of 307 days as of today, and orders you to pay your attorney's fees, court costs, and lab fees. And Mr. Upshaw, before you go, did you get an opportunity to review the judgment in your case? Was your name, the charge, and the time credit correct? All right, sir, now that you've been finally convicted of this felony offense, you are now under Texas law and eligible to possess a firearm or ammunition. If you have any questions, sir, consult an attorney. You're now remanded back to the custody of the sheriff for transport to TDC to serve out your sentence. Good luck to you, sir. You need to see the bailiff before you have a seat.
Judge. For Brad Gillett McIntyre.
McIntyre?
Yes, sir.
Oh, I see it. You have that, please. Why is Miss Harris still here? We've done Miss Harris, haven't we? No. Miss Harris, didn't I call you up already?
Yes.
And I gave you a reset date. Oh, okay. Oh, okay. Well, she's tested negative. Why'd she need to see me again?
Your Honor, you just said you were gonna hold off on the reset until after the drug test. It's a status, but we were requesting a reset.
November, let me call it before we get into the plea. She's been sitting back. I've been looking at it thinking, I don't know why she's still here. I could find the case. All right, this is cause number CR 21-0087-173, the state of Texas versus Kimberly Harris. Ms. Harris's drug test was negative. I'm resetting status to November 10th at 1:30. We'll see you November 10th at 1:30, ma'am. Remember those conditions of bond. We'll see you then. Yes, sir. Appreciate you. Sorry about that. I was looking at it thinking. All right, and Mr. McIntyre, come on up, sir.
And Brad had to leave, Judge. He had an office with people and a lawyer there for a settlement conference.
That's fine.
Wanted to make sure that you did.
As long as somebody's here to handle it. I'm sure Mr. McIntyre is glad you're here, or we would have had to reset him for another couple of weeks.
Yeah, he wouldn't be happy with that, would you?
Give me a minute. Let me sign him. and then we'll go. All right, this is cause number CR 21-0594-173, the state of Texas versus Dylan Thomas McIntyre. And that is set today for status. However, a plea has been presented to the court. Is the state ready?
We are, Your Honor.
And on behalf of Mr. McIntyre,
Ready, Your Honor?
sir, is your name Dylan Thomas McIntyre?
Yes, sir.
And are you the same person that was originally indicted in, is he pleading to count two? That's what it says on here. I just want to make
Yes,
sure.
sir. We're asking the court for 1245 count one.
Okay, are you the same person that was originally indicted in count two of that indictment with the third-degree felony offense of possession of a controlled substance?
Yes, sir.
And get you to raise your right hand the best you can, please. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand. Mr. McIntyre, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. McIntyre, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today?
Yes, sir.
And Mr. Stevens, do you believe that the junior Mr. Stevens client is competent?
Yes, I do, Your Honor, and I met with him yesterday also.
Okay. Well, he's been in the court many times too. I had no reason to doubt his competency, and so the court is finding him competent. Mr. McIntyre, I know that we've already arraigned you on this case. However, would you like the prosecutor to read that indictment out loud here in the court?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted in count two, that charge is a third-degree felony, which carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand the range?
Yes, sir.
In the plea bargain?
Your Honor, we're asking the court to defer finding of guilt, place the defendant on probation for a period of 5 years. The attorney's fees, court costs, and live restitution. We're asking the court to consider and dismiss count one of this indictment.
And is that your understanding of the plea bargain, Mr. McIntyre?
Yes, sir.
Is that your understanding, Mr. Stevens?
Yes, sir, it is.
And Mr. McIntyre, a few minutes ago, you told me you could read and write the English language. Got two documents I'm going to go over with you. The first is the agreed plea recommendation. Did you read and go over that with Mr. Stevens?
Yes, sir.
And did you sign both the front and the back of that document?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign there on that second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Stevens?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury.
Yes, sir.
Do you want a jury trial?
No, sir.
Do you want to do this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to count two of that indictment, that third-degree felony? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I'll hear the evidence.
Judge, I have states 1 in offense report and states 2 is not report compliance.
No objection.
Admitted.
It rests.
Defense rest.
All right, then, Mr. McIntyre, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will follow the plea bargain, defer making any finding, considers count one in punishing you, places you on 5 years of community supervision. You do have 3 days credit as to any sentence you may eventually have to serve, and orders you to pay your attorney's fees, court costs, lab fee, and abide by all the regular and special terms and conditions of community supervision. And Mr. McIntyre, have you ever been on probation before?
No, sir.
How old are you?
20.
20, just a baby.
Yeah.
Don't take any offense in that, but you're young. Well, Mr. McIntyre, if you violate even one term or condition of this probation, a motion could be filed, a warrant would be issued for your arrest, you'd be brought back before the court, and if at a hearing, the court found it were true that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 10 years in prison. You understand that?
Yes, sir.
So would you agree with me? It's extremely important you abide by these terms and conditions.
Down right here, sir.
And I know the reason that you're in jail clothes because yesterday you tested positive.
Yes, sir.
If you got a problem, you need to get a hold of it real quick for one, for you, you're so young. You could solve it now. And two, you don't want to end up in prison. You slipped up. I know you did, but I've got faith in you. I hope I don't see you back in here on this. Good luck to you, sir. As soon as you get out, you need to contact and see probation.
And I forgot to give you the word.
It's okay.
Just a second.
And then Mr. Harris is the last. Cody Harris, or Dustin Harris, sorry, come on up. Mr. Harris, I had you fill out the paperwork and apparently you do not apply and you still want to hire Brian Schmidt. Is that correct? All right. And I know you got a job you're trying to finish up and I want you to work, but I have to treat everybody pretty much the same. Are you still planning on hiring him even from jail?
Yes, I mean,
Okay. All right. Well, then, we're gonna reset. now. Did we? I'll say him as soon as possible. Mhm.
Go ahead. Mr. Smith will be here on this docket, so.
November 3rd, 9 a.m. So we'll see you then. Make sure you tell Mr. Smith and you'll get a copy of that November 3rd, 9 a.m. Thank you, sir. Good to see you. Sure can, happily.
Harris.